We'll hit it harder.
Call the meeting to order. This is the September 11, 2018 meeting of the Town Planning Zoning Commission of the Town of Fairfield. The first item on our agenda are the meeting minutes from last meeting, August 28, 2018. Motion to approve by Commissioner Francis. Second by Commissioner McAleese. Any comments or discussion on those? I did not see any issues. Commissioner Francis?
No.
Okay. You have an eagle eye, I've learned. Very good. Ready to vote? All in favor signify by saying aye. Aye. Any opposed? Abstentions? Minutes are approved unanimously. Next item is another communication. Do you want to announce this?
Sure. Mr. Chairman, it's not on the agenda, but distributed in your packet is a notice for our next meeting, which will be 2 weeks from tonight on the 25th. We'll be holding our second public engagement session for our transit-oriented development planning session at Penfield Pavilion. We did a very successful first session that was very well attended. So for the folks that may watch this on Fair TV, or those of you in the audience this evening, we have flyers available. Press release went out today for phase 2 of this. This will be in lieu of a regular commission meeting, so it's already calendared for you folks. It'll be again in Penfield Pavilion to hear the results of the market analysis that our consultants have done, and to engage the public again in some some public exercises to gain public feedback. So we would invite any interested citizens to attend Penfield Pavilion on Tuesday, September 25th, and there's an Eventbrite RSVP link that's live and active. So if you're planning on attending, please register, and we will welcome anybody in our audience this evening and those at home to also participate.
That's great. Thank you. And that will be pushed out to all the distribution lists?
It will, yes.
Okay. And this is a Fairfield Transit-Oriented Development Study. This meeting will examine the areas within a convenient walk of the Fairfield Metro Center and Fairfield downtown train stations to identify strategic opportunities and types of development that support our economic and community goals. So please come and participate. Thank you very much. Next is new applications to recommend to public hearing. First is 500 Algonquin Road, special exception application of Brooklawn Country Club for new maintenance buildings and relocated paddle tennis facilities in a AAA zone.
I have nothing to add, Mr. Chairman, besides that description. It is a special exception. A proposal does require a public hearing.
Okay, thank you. Can I have a motion by Commissioner McAleese, second by Commissioner Corcoran. Any discussion? Okay. All in favor say aye. Aye. Any opposed? Abstentions? Move to public hearing unanimously. Next is 620 Villa Avenue, special exception application of Russell Speeders Car Wash for site plan and access changes in a design commercial district.
This is proposed site plan amendments. It is a special exception use, therefore a special exception. They're looking to modify the way they access their site for certain customers that have unlimited wash club or whatever it is. There's going to be a dual access to help, hopefully, help reduce the queues that currently stack up on Greenfield Street. But again, it is a special exception. Proposal does require a public hearing.
Okay, very good. Motion by Commissioner McAleese, second by Commissioner Corcoran. I'm not aware. Have there been some issues with the queuing of the cars?
Well, it's been an ongoing thing for years, dating back to Villa Avenue Car Wash. They just have an alternative proposal, more so for their interest in selling an unlimited wash ticket that allows you basically to cut the line. So essentially, that's what this is all about.
Oh, I see.
So there'll be some site improvements to allow a way to facilitate that.
Wow. So if you buy the pass, you get to cut the line.
Correct.
Okay. Any further discussion? All in favor say aye. Aye. Any opposed? Abstentions? It's moved to public hearing unanimously. Next is 5151 Park Avenue, special exception application of Sacred Heart University pertaining to a new maintenance building in the R3 zone.
Again, nothing other than what the description says, although the access to this new building is proposed will actually be off of Jefferson Street, but it is part of the university property, does require a public hearing.
Okay, thank you. Motion to approve by Commissioner McAleese. Second by Commissioner Noonan. Thank you, guys. Any further comment or discussion on this? Okay. Very good. All in favor, say aye. Aye. Any opposed? Abstentions? It's moved to public hearing unanimously. Next is old business, 449 Mill Plain Road, re-subdivision application of the Sturgis Cottage LLC for 2 lots in an R2 zone.
Mr. Chairman, this is a 2-lot subdivision heard at our last meeting. There's really no new site construction proposed at this time. If you're familiar with the historic Sturgis Cottage, there's a carriage house behind it. The idea here is to create a separate lot so they could create a separate dwelling within that structure, so create some rental income to help maintain this historic structure. One of the issues that came up at the hearing was a question about the sight line for the existing driveway at Mill Plain and Sturgis there. We do have a report from our engineering department that said that the sight line was inspected at 449 Mill Plain Road. The sight line looking north is fine. However, the sight line to the south just needs some clearing. There's some existing Andromeda and holly trees that just need to be trimmed in order to create the sight line. But that's a straight shot. The sight line is available with some appropriate removal and/or trimming of existing vegetation that's easily achievable.
Okay. That's on Mill Plain. What about the driveway on the cottage?
There's no...
Wasn't there...
Yeah, this is for what would be the new dwelling lot.
Right, okay. Very good.
Beyond that, I have no further comment.
Okay.
All that trimming you're talking about, plant removal, is, I take it, on
It's within the frontage of this property.
of this property or
Yes.
the main house?
It's within the frontage of this proposed
Oh, that's
lot.
fine.
So, if you want to make a motion, I suggest including the condition. All right.
Move to approve with the condition that the vegetation and that was cited by the engineering department be maintained, to be cut back so an appropriate sightline be maintained.
Thank you. Motion by Commissioner Noonan, condition as stated. Second by Commissioner Corcoran.
Aside from the condition as requested by engineering, or at least going to be required for the sightline, seem to meet every other regulation, so I have no reason to deny.
Right. Very good. Any comments?
I have a question. I mean, if the Andromeda are trimmed back, they will grow back. What mechanism do we have to see that that's maintained, the sightline is maintained?
Well, it would either be removed or trimmed. I would think that if someone is going to be using that on a regular basis, it would hopefully be a kind of a self-policing thing, that if they can't themselves see out of the driveway, that they would know to do that. But we can establish the final map can show a sight line triangle that must be kept clear. I mean, it could be delineated on the final map.
So you know, the question that you ask, or the circumstance that you propound is one, I think, with all approvals, right? How do we know that they're going to maintain what it is that we approve? And there are lots of times when that doesn't exactly happen. I mean, in this circumstance, I think that the condition of approval is that the sight lines be established through the pruning and other cutbacks, whatever you want to call it, of the vegetation. My question, I think, to your point, is how do we know that that's happened? All right. I mean, typically we will get you know, an approval on the sight lines from engineering, but here the comment back is that they don't presently exist. How do we condition this approval on that basis.
Well, I think what the report says is the sight line is there absent the shrubbery. So if the shrubbery is removed, they're fine. So I would, to bolster Commissioner Corcoran's comments, is they could show the requisite area that needs to be clear on the final subdivision map to,
Okay.
just to bolster that. If
Yeah.
that lot were ever to be sold in the future, then that map would
Right.
be part of the record.
And presumably, if that was a matter of public safety and that sightline fell out of compliance, it would be a zoning enforcement issue as to the site plan with the current owner, right?
That's correct.
Yeah. All right, so it really isn't just a condition of approval that they actually do the trimming, it's that the sight line, that's,
So they maintain it.
that it be reflected
Achieve
on
it
the site
and
plan.
maintain it in the future.
Right, and then that it be reflected on the site plan. All right, so you accept that, Commissioner Noonan?
I do.
Yep, and I think it was Commissioner Corcoran?
Yes,
All right.
yes, I do.
All right, thanks. Commissioner Francis, you had a comment?
The
Can you
carriage house,
speak-
is it going to be remodeled, or do we know?
We don't know at this
Or
point.
removed? I just wonder if that will impact the historic designation, if they remove it.
Yeah,
Carriage house.
I don't know what the plan is at this point.
Yeah.
I believe they're going to try to do a dwelling unit within the existing structure, but again, that remains to be seen.
Yeah, all right, thank you.
Yeah, and it's beyond our purview in terms of
Yeah.
historic, and if they need historic approval, then that's for them to pursue. Commissioner Corcoran?
I just wanted to clarify, I wasn't suggesting that the bushes be removed, just that
Right.
they be trimmed.
Right. That not just one-time thing, that it be maintained at all times. Yeah.
Okay. Anyone else have any other comments? Okay. The motion is to approve with the conditions as stated. All in favor, say aye. Aye. Any opposed? Abstentions? Okay. The re-subdivision is approved with conditions as stated unanimously. Next is our public hearing. The first item on the agenda is resuming 65 Station Street, special permit application of SF Station Street LLC pertaining to a new commercial building in the neighborhood design and residence A zone. We last left off with Attorney Green representing the Neighborhood Association. So I'll call him back up to the podium. And then for any other members of the public that are here, when he's complete, you can have your opportunity to say any remarks you might have. When the public is finished, the applicant will have their rebuttal. The public hearing will then be closed. Okay?
Thank you, Mr. Chairman. Members of the commission, staff, once again, my name is Joel Green. I practice law in Bridgeport with the law offices of Green and Gross, and again, I appear before you this evening on behalf of the Station Street Neighborhood Association. There is just a housekeeping matter that I spoke with Attorney Fallon about briefly, and as I understand it, there are some new materials that have been submitted to the commission that I think should be addressed preliminary to my presentation, and specifically, I'm referring to an email and apparently a sketch that's been prepared, and I don't know that I actually have. I'd be pleased to have you submit it.
And I'll just provide some background on this. This matter originally went to a code enforcement review in October of last year, Yeah, John Fallon for the record. This matter originally went to a code enforcement review in October of 2017. At the time, there were comments from the fire department, and those comments were complied with. Yesterday, Mr. Wendt and I received an email from Fire Chief McCarthy. He had seen the plan, and his only concern was that we might be able to demonstrate that we could provide a hammerhead turn sufficient so that if he had an emergency vehicle situation, he wouldn't have to back the entire emergency vehicle back out of onto Station Street. So we met with the chief, and we prepared at his request a sketch. We gave that sketch to him yesterday afternoon. I gave it to Mr. Wendt. I have copies of it here for everyone. And the chief did send Mr. Wendt an email today, which I know Mr. Wendt was going to make part of the record. I'll let him read that, but basically approving the sketch and the site plan, having demonstrated that we can provide him with the turning radius. This is the
Copy is in the file? Yep.
Yes, Mr. Wendt has a copy.
Thank you. Do you have a copy of this?
I do, thank you, Mr. Chairman. But I guess my question is, just for a point of clarity, is this now a part of the application? I'm not sure specifically what the applicant is requesting of the commission by virtue of submitting this.
It does nothing to change the site plan. It simply is a demonstrative sketch that the chief requested, showing that we could create a grass-created...
I understand. I understand. And if there's a question about the purpose of this, then you should raise it. And Mr. Fallon, if he thinks it's appropriate, can address whatever comments he has on rebuttal. Okay?
Okay, so I guess not okay, just to the extent that I'm just not sure. It's a document that's been submitted. Apparently, the fire marshal has submitted an email, and I'm not sure whether that email is part of the record, but I
It
believe...
is.
And the fire marshal apparently has taken the position that a turnaround is needed as a condition of the approval of this development.
No. As I understand the email from the fire marshal, the plan as reviewed by them needed certain conditions for approval, which the applicant has agreed to, and that email lists those out.
Okay.
And that's all it is. So, to the extent that this sketch, and I don't think you can call it much more than that, although it does say that it is to scale, purports to show that they are capable of a fire truck turning around in the parking lot to the satisfaction of the fire department. That's my understanding of what it is. And the email, as I think we all can, I mean, it's not argumentative, it speaks for itself.
So, as I understand, and I have a copy of the email, and I understand that there's a copy in the record, but this was received by the commission today at 10 of 1, and just so that the record is clear, the email requires that there be improvements to create a turnaround using some sort of a grasscrete or similar product capable of supporting Fairfield fire apparatus with a gross vehicle weight of 44,000 pounds on a lawn, and an effort to maximize a turning radius, including on-site consultation with the fire department. Snow removal on the grasscrete pavers will be included in the site maintenance agreements, and signage that prohibits parking in that area. And just the record should be clear that based on my understanding of the sketch, this improvement would be one that would be created on a lawn area that is located in that portion of the property that is a residential zone.
And you're free to now take up these facts however you deem fit.
Thank you, Mr. Chairman. That's exactly where we are. So the first item I wanted to cover would be to distribute to the commission individual copies of the exhibit that I had displayed to the commission at the last hearing. And I have a larger scale one for the file. And then usually And similarly, the second exhibit and I'll submit these to Mr. Wendt electronically tomorrow as well.
Thank you.
So just that housekeeping matter. So what I'd like to do now is just briefly, I have two members of the Station Street Neighborhood Association who would like to briefly address the commission in the context of my presentation and as a precursor to some of the issues that I'm going to be raising. And the first individual is Eileen Bohan, who lives at 51 Station Street, who is just going to very briefly address the commission.
Okay.
Good evening, everyone. My name is Eileen Bohan. I live at 51 Station Street, which is right next to 65 Station Street, where the proposed office building will be built. One of my biggest concerns is safety. I'm very concerned about safety. And I'm also very concerned about value of property. I have a rental that will be going up for rent very shortly, and I am concerned about being able to rent this unit with the possibility of this office building, the congestion, the parking, and the safety. So I ask you, please consider that as an indication that my property value will drop, and I may have a very difficult time getting a renter. Thank you.
Thank you.
Next is Sarah Michaels of 176 John Street and Jane Sutherland of 172 John Street, who
Okay.
will address you jointly if you don't mind.
All right, thank you. Please, welcome. Come on up and just state your name for the record.
Hello. We are both the beneficiaries of...
Can you just state your names for the record?
I'm Jane Sutherland.
Sarah Michaels.
Thanks very much.
We both live in a side-by-side on John Street. 2.5 years ago, I moved to Southport from another section of Fairfield, the beach area actually, and took a risk of living near a train station, and I thought it had character, and I would really urge this committee to consider the character not only of that neighborhood but of Southport itself. Was told that Fairfield did not want to discourage business development. I don't see any reason why that little plot of green space needs to be developed.
I have become deeply concerned about the value of my property at 176 with the advent of what this development may mean. And on a more sensitive, emotional subject, the view of the church is so important to not just me, but I believe to everyone who lives in the Southport Village. And the idea of that landscape changing in the name of this project makes no sense to me. But when I purchased 176 John Street, it had so much to do with the feeling of the village and the beautiful vista of that church. And anything that would develop near it that would mar that is deeply, deeply concerning, and I know it would affect the value of my property.
Okay. Thank you very much for your comment.
So I'd like to just briefly give the commission a little bit of background on, you've heard from a lot of neighbors. In fact, all of the neighbors that you've heard from are in opposition, and all the members of the Station Street Neighborhood Association, which comprises most of the residents of the area, oppose this development. And I thought that it would be very helpful to the commission to provide you with some background as to really what happened here and what has occurred in the past few years. And the chairman asked a very interesting question when I presented that drawing that was accompanied a certificate of zoning compliance. I had looked at that application, and I think it would be interesting to illustrate sort of historically what occurred with respect to this property. And that history is very well summarized in the application for certificate of zoning compliance that was submitted by Sturm Ruger and Company back in 2010. And I have a copy of the application, and I'd like to just briefly go through it with the commission. And it's pretty interesting because, and I know you don't have this in front of you yet, but it was a certificate of zoning compliance that accompanied the drawing that I presented to you. And the letter of intent that was submitted to the commission speaks largely about Sturm Ruger and Company, which was established in 1949 in Southport. And it's been and the letter of intent said that Sturm Ruger is a major contributor to Fairfield's economic strength and vitality for over 61 years. And again, these comments were made in 2010. And the corporate offices of Sturm Ruger are located on Lacey Place, and in fact, they still are. And this application goes on to state that for 48 years, the company was located at 65 and 75 Station Street. And again, that was established in 1949. But in 1959, it moved some of its operations, but maintained a presence at 65 Station Street until 1997. It then goes on to recite that from 1997 to 2005, the property was used for a law office and for an antique store. And again, those are uses that are specifically authorized in a neighborhood design business district. The antique store continued to occupy 65 Station Street until 2008. And there was also a dance studio, as I think you heard some of the public speakers say, used on that property. So historically, the property was very consistent with the neighborhood design business district. And what happened was, this letter of intent was written because Sturm Ruger said, we want to reoccupy our former office, so we want to reestablish our historic home on Station Street. And the reoccupation will include an aesthetic upgrade, an improvement to the exterior of the building, as well as ensuring that the entire structure remain in compliance with all aspects of the code. And the applicant points out that the property is located in a neighborhood design business district with a small portion lying in Residence A. And it talks about the parking. And it says that basically, it goes on to say that we went to the Zoning Board of Appeals and we got a variance because we recognize that while historically Sturm Ruger was there and Sturm Ruger's use predated the zoning regulations, there was a zoning regulation enacted that established the neighborhood design business district, and we, Sturm Ruger, are not technically compliant because we're not providing goods and services convenient to the neighborhood. You know, we're a company that sells firearms worldwide, but we were there for 48 years, and we're really reestablishing a historic use. And in fact, the applicant points out that no one expressed opposition to this request, and indeed the company submitted numerous letters from residents and organizations, because everyone in the Southport community said, we have this opportunity to almost go backwards to the way it was. We had a relatively quiet office operating on this site, and we will embrace, you know, Sturm Ruger moving back into the neighborhood, and that's okay. And in fact, on that basis, and with the concession and agreement and acquiescence of the neighborhood, the ZBA, in reliance on that, granted the variance saying, okay, we're going to let Sturm Ruger move back in. And in fact, then there was a certificate of zoning compliance, and with the variance that was granted, the certificate of zoning compliance was granted, and everything was great, except that Sturm Ruger never moved back in. And instead, what happened was, it became a Ravis office, and ultimately now, a home to Penfield Marine. So some of the neighbors are understandably a little upset because, fool me once, and they basically felt like somewhat betrayed, I suppose, by the fact that they, based on an old, long-standing relationship, they had agreed to this variance, and instead of getting the Sturm Ruger company and going back, it ended up becoming a home to a sort of a high-volume user and a company that has of worldwide use that are non-conforming. Yes, Mr. Chairman, I see you requested.
This is the certificate of zoning compliance after they got the
Variance.
the variance
Correct.
at the ZBA.
Correct.
Is the application for the variance before the ZBA in the record?
It's not. And I don't know that the records of that are still available.
What was the nature of the variance?
The variance was simply to vary the use for the existing structures, the structures that existed, that are the two existing structures now, to allow what was technically a non-conforming use
As a business office?
as a business office.
So would you argue that the proposed use presently for the new building being proposed in this application is not a conforming use within the neighborhood design business district? Is
I
that-
would argue that the existing uses are not a conforming use, and I would argue that, well, what you might argue, or what might be argued, would be that it's a non-conforming but permitted use because there was a variance granted for a business office.
And that's my point, right? So
Correct.
The variance was, runs with the land
That's correct.
for a business office in
That's
those
correct.
two buildings.
That's correct.
And
However,
I think your argument is that the fact that they sought a variance previously with respect to those buildings for business offices is evidence that they need a variance, that the present application is not in a conformity with the regulations. And that they would
Exactly
need a
that.
variance for the same kind of business office for this new building.
precisely. So it's an expansion, it's a proposed expansion, and I would submit that...
Was the variance granted with respect to the buildings, or was the variance granted with respect to the parcel?
I would suggest that the variance was granted with respect to the parcel as it existed at the time, and there was a site plan submitted. And it's an now there is an intensification of that use.
Okay.
I would also submit that at the time, as the site plan that was submitted, that I've submitted into the record, was a different site plan than the site plan that is in evidence now.
Very good, thanks. Does anyone else have any other questions on that? Thank you.
I would also submit that that if there's any question, and once again, I have the issue is not as to the desirability of a Ravis office or Penfield Marine, or I'm not being critical of them as businesses, but I'm just identifying that they are not businesses that are permitted in they're not businesses that would ordinarily be permitted in a neighborhood design business
No,
district.
I think we understand the argument that you...
And I would just like to submit an excerpt from the Penfield Marine website, which is a portion of a screenshot that basically speaks to the fact that from its offices in Southport and London, Penfield provides shipping services to a wide array of clients, which include chartering customers, major oil companies and oil traders, pool members, and shipping investors. And pool members, I believe, are entities that have shipping capability or shipping interests. So I just want to submit that into the record. The next issue that I wanted to discuss with the commission was that the proposal is for offices, and as I had argued when we last appeared before the commission, Mr. Galante's report really evidences the fact that the on-site parking is not sufficient by a single parking space. And my concern was, and at peak, it is not by definition capable of providing adequate parking, and that's demonstrated in Mr. Galante's report. There's an instance where on a Wednesday, the parking capacity based on using the data that he uses does not provide adequate spaces. And I want to bring to the Commission's attention Section 25.3 of the regulations, which speaks to special permits, and I have copies with it. And just to summarize, 25.3 provides that a special permit use, in order to change, it says any revision of an approved special permit application and any change, including use in any reconstruction, enlargement, extension, moving, or structural alteration of an approved special permit use, or any buildings or structures in connection therewith, shall require submission of a special permit application as for the original application, except in the following instances. And one of them is business and professional offices, banks, and medical and dental clinics. So, in other words, there could be an automatic change from a use such as Penfield Marine to a much higher higher intensity use like a medical office, a pediatrician, and the like, that would require that would produce a much higher traffic count than, for example, Penfield Marine might. And so that once you allow an office use on that site for business and professional offices, this really says that you can shift that from a business or professional office to a medical and dental clinic without filing for a special permit. And I think that's an important distinction and something that's important for the Commission to consider with this application. I have a calculation for the Commission that I'd like to share that talks about traffic generation calculations for a medical office use, for example, and I'll submit that to the Commission. And what this basically proves, and this is using the same database that Mr. Galante used, only instead of using general office, it uses medical and dental office building as the classification. And once again, under our zoning regulations, you could shift a business office to a medical or a dental office without reapplying for a special permit, and the impact of that would be to produce a much higher burden and much higher use of the property, and it produces many, in this instance, the data, and this is from the database, the same database that Mr. Galante used, ITE calculations, only it's medical and office, and I provided you with the actual search data, and it shows that instead it increases the daily vehicle trips for just that office for a 3,560 square foot medical office. ITE calculates 124 daily vehicle trips, which far exceeds the office figures that Mr. Galante had produced in his traffic report dated July 6th. And it would provide during the peak hour traffic of 10 cars, 8 entering and 2 exiting, and during the PM peak hours, 9 exiting. So the point is there would be several more cars in the morning and therefore less available parking on the site, and it further proves the fact that the site parking would be inadequate on the site if the medical office, for example, were to end up in that building. And once the gates are open as an office building, that would be a real reality.
So, just so that I don't have to look it up and stop you, what was Mr. Galante's calculation of daily vehicle trips for the proposed use?
I believe it was,
I don't recall that.
I have it right here.
calculation. I recall the peak numbers.
The total was, vehicle trips would be 4 in the morning and 4 in the afternoon.
And I don't recall a calculation of daily vehicle trips, like a sum cumulative total in his report.
Yes, it's in his, just one moment, I have his report. It's 12, it would generate, the proposed office expands 3,600 square feet of floor area and is estimated to generate an additional 4 vehicle trip ends during the weekday morning and weekday afternoon peak hours based on trip generation rates provided by IT. Therefore, the total future site traffic generation will generate 12 trips during each of the typical peak hours. The additional traffic will have a minimal impact, if any.
12.
And
12 trips during each of the morning and afternoon peak hours?
just a moment. So instead of there being 10 cars entering during the peak hour, he's predicting 4 during each of those hours. And
Okay. And is there a calculation for the daily total, as you've done?
I believe it's 12 trips.
Okay,
I'm not
that
sure,
seems-
I think Mr. Galante, I don't know if Mr.
All right.
Galante is here.
We'll
He
look
can-
it up. I don't want to interrupt you. I thought if you had it, or you could put your finger on it, it would be helpful. But,
Next is the, I'd like to address the, this new condition that's been imposed, and I would suggest, and the reason I asked the questions I did regarding the status of that turnaround is because, as I had indicated earlier in my remarks, what is really proposed is a turnaround and a constructed, an engineered structure in the lawn. I forget what the exact phrase is, grasscrete or other products. So there'd be a structure constructed in the lawn, which is all located, or mostly located in the residentially zoned portion of the site. And I would submit to the commission that that would not be a permitted use in a residential zone, because essentially what that would be is an accessory use, as an accessory to the commercial use being the office buildings, meaning the fire marshal has determined that in order to allow the safe operation of the site with the addition of this 3,600 square foot office building, he's saying that they have significant concerns about backing a fire truck out. Therefore, it's in order to operate it safely, and it says in the letter, Mr. Wendt, the Fairfield Fire Department, approves the site plan. The developer has agreed to several conditions that make this project much safer for the fire department and other emergency services. And the turnaround would be located in a residential zone, and as you're all aware, and as I've raised to this commission, our zoning requires that uses that are not specifically permitted under the zoning regulations are prohibited under our zoning regulations, and the your regulations do not allow an accessory to a commercial use in a residential zone. And that accessory is merely to, once again, to accommodate fire and safety vehicles so that they can adequately serve these commercial buildings. And the turnaround structures are located in a residential zone, which is not permitted under the zoning regulations.
so just to be clear, it's your understanding that the area where they would do these pavers is in the grassy area?
It's actually shown on the site plan, the turnaround, on the drawing that I received. The turnaround is shown as a square, and it's a back-in,
I see.
so it
So
looks,
that's adjacent to the existing parking, but there's already parking, commercial parking in the residential
Yeah, and as the applicant pointed out in that certificate of zoning compliance, there was, I think it's the claim of the applicant that there was residential, that there was commercial parking in a residential zone that predated the imposition of zoning regulations.
So that's a pre-existing nonconformity,
Correct,
and I suppose another argument would be this would exacerbate
correct,
the pre-existing nonconformity, which they're not permitted to do.
correct,
If they can't do that, then they don't have a turnaround, an adequate turnaround.
correct,
And therefore, the site plan is not safe.
correct.
Got it.
And our regulations, and once again, any existing parking spaces that are in the residential zone may be legally existing, but they're non-conforming to the zoning regulations because in Fairfield, you can't have parking spaces serving a commercial use in a residential zone. So, so I would suggest that while the applicant may have agreed to that condition, it would not be legal under the zoning regulations. So essentially, it's the claim of the Station Street Neighborhood Association, and it's our request that the commission deny this application. And I understand that on some level, you know, you're looking at a 3,600 foot office structure, and I understand that in the grand scheme of things, in terms of some of the projects that this commission considers, I understand that that may not seem, you know, like a vast or large structure. But I think, as you heard from speaker after speaker who lives in the neighborhood, and once again, I know I've made this, I've offered these comments several times to the commission. You know, everyone produces experts, and on every application, or in many applications, you have experts on both sides, and so each of them advocate and they offer opinions, and they use the ITE numbers, and they use data, and they provide an educated opinion based on, once again, modeling their experience, their education, and they offer an opinion. But in this case, you have the testimony of almost everyone who lives in the neighborhood who stood up before you and said, there is a real traffic problem here. There is a parking problem here. There is a congestion problem here. And I think that everyone in the neighborhood views adding this as a real tipping point, because there's already, and by the way, there's, as you know, a train station there, there's an expanded restaurant there, and it's a relatively narrow road. So I've also said to you before that in every instance, every applicant has produced a traffic expert, and in every instance, I've never heard an applicant's traffic safety expert say anything other than, this application won't produce any significant incremental change in the amount of traffic. And yet, as we all know, as we drive through downtown Fairfield and so many other neighborhoods in our town, all of those applications and all those projects that have been constructed have in fact produced a significant volume and a significant issue. And so certainly these neighbors of this project are justified in their significant concern about the impact of adding another use. And while they wished, the applicant well and his tenants well, and they appreciate the contribution and the many contributions to the neighborhood and to local businesses and the good character of the applicant, what they're really concerned about is the quality of their lives as well. And it's a delicate balance that this balancing that this commission certainly does in assessing these applications. But I would suggest that this really does not meet the standards for the issuance of a special permit. We've talked about the setback issue, so I would suggest that in many ways this does not meet the standards of your regulations, so it's not zoning conformant.
Could we, you talk about that for a moment? I want to understand, make sure I understand your zoning, your setback argument clearly. And you also handed up these two exhibits, which I don't think you've spoken to.
I presented them to the commission, but it was late, and I'd be happy to go back through them. And basically, it was my what my argument was, first of all, the site plan itself is defective because it does not show that the zone line between, let me just get my copy here.
And it looks to me like these are the same thing, but one has a dark red line on it with a notation at what I believe to be 30 feet,
Correct.
coming from Evelyn Wynn's property at 504 Pequot Avenue.
So
So,
what I had presented to the commission was, first of all, as you recall, I presented an excerpt from the zoning map, the original zoning map of the town. And what I had shown was that, and you can match up this zoning map with this exhibit that I had produced. And the site that is the subject of this application is a split zone property. It is Neighborhood Design Business District, and it's also Residence A. And the Neighborhood Design Business District portion of the site is approximately 32,000 feet. The residential area of the site, Residence A zone, is approximately 11,000 feet that make up the approximately 43,000 feet of this property. So it presents two zones, a residential zone and a commercial zone. The applicant had failed to depict on the area behind the building, and I've shown it as a pink and yellow line. The pink, and I was trying to mimic the zoning map of the town, and the zoning map shows the Neighborhood Design Business District with a pink outline, and on the map that I had provided to you, it shows the Residence A zone in a gold outline. And you can see basically the same bend that's right here on the zoning map is the corner right here. And the applicant had failed to depict the fact that the boundary line directly behind the building is the boundary line between a Neighborhood Design Business District and an R2, Residence A zone, rather.
right, okay, understood.
Then,
And neither of those boundaries are noted. NBD Residence A. Okay. And I don't think there's any dispute that that rear property line of the subject parcel is Neighborhood Design Business District on the parcel, and on the church's property,
correct.
Residence A.
Correct. And the point is, under Section 12 of the, Section 12, once again, 12.7.6, which I had provided to the commission, I'd provided, first of all, the standard for a Residence A zone, and then I'd provided the regulation 12.7. And the significance of that is it spells out in neighborhood, in all of the sort of, in all of the design business districts, it set forth the various required setbacks. And it speaks to a front street line setback, which is defined in the regulations, a sideline setback, and a rear line setback. But then it has this special classification for adjacent residence district boundary. And what it says, and the way the building was designed, was it says the setback shall be 10 feet and or the same as that of the adjacent residence district setback requirement, whichever is greater. And in this case, what happened was, this is a rear yard setback, and the applicant used 10 feet, which might,
Rear yard setback.
yes,
So the church's property has, on the front is Pequot.
yes,
On the back is towards the railroad,
Mhm.
and the side is adjacent to this property and the other side of the church. Why is that not a side lot line?
Because it's a rear lot setback for the applicant's building.
Yeah, okay, do you agree that it's a side lot line for the church's property in the Residence A zone?
Correct?
Okay.
However, I think, first of all, in the regulations, I'll note, and in the excerpt that I had provided to the commission, you'll note that in residential districts, the rear lot boundary is larger. And many times, the street line setback is large, the rear yard setback is larger, and side yard setbacks are slightly smaller. And that's because,
But the subject parcel is in the Neighborhood Design Business District.
that's correct.
Which has a rear setback of 10 feet.
Correct.
So as between the two, the regulation says we should use either 10 feet or the other if it's, whichever is greater. So if that's a side lot line in Residence A, which
Yeah.
is a setback of 7 feet, and a 10-foot setback in the Neighborhood Design Business District, we use either 10 feet or whichever is larger. Why is that not 10 versus 7, and 10 is the answer?
Because I would argue that that the applicant, in this case being in a neighborhood design business district, that's a rear yard setback for them. And they would use the rear yard setback requirement in order to, so that it would create the same effect between residential properties. And I believe that that was the intent of the regulation because it provides that greater rear yard setback that's allowed, that's required rather, for residential districts.
But 12.7.6.3 in the Neighborhood Design Business District is a rear property line setback is 10 feet.
But that's in between commercially zoned properties.
I mean, the next section deals with this situation.
That's
which
correct.
Which is where you have an adjacent residential district boundary on a Neighborhood Design Business District. You take it's either 10 feet or the same as that of the adjacent setback, which here appears to be a side lot line with a setback of 7 feet.
I would argue that it's a rear yard setback to an adjacent residence district. And you pick up, even though it's a rear yard setback, it's a rear yard setback for the commercially zoned property. And I would argue that what the regulation
10 feet.
says is that you adopt whatever setback you are bound by in the commercial district has to pick up the residential standard.
So even though that parcel is in the Neighborhood Design Business District and 12.7.6.3 tells us the setback should be 10 feet, your argument is because it abuts a parcel in the Residence A zone, it should have a 30-foot setback on its property.
Correct, because it is a boundary line to a residence district boundary.
Well, isn't the other building also within 30 feet of that property line?
Which
I'm
other
just
building?
curious. The existing building. Is that?
I don't think so.
I mean, certainly, they're all within 30 feet of the rear lot lines of these homes that are on Pequot Avenue.
But these buildings predated the zoning requirements.
So those are all pre-existing nonconformities.
Well, these are completely non-conforming.
No, even with respect to the second building on the lot there?
They are, because
Okay.
they were existing before the boundary lines were drawn.
Okay. So, and I think, does anybody have any questions on the side lot line of the church further there? No? Okay. So,
Well, I have a question about what you just brought up, about the other.
that's where I'm going next. you've drawn a red line on one of these exhibits from Miss Wynn's property at 504 Pequot Avenue, which appears to me to be a rear lot line,
Yes.
and extended that line 30 feet into the subject parcel, which does not appear to, you show 30 feet there. On the site plan, it shows 86.8 plus or minus.
Well, that's a side yard setback.
What?
What's the 86?
Right? Yeah. So on,
They're showing that 86 feet as a side yard setback.
well, regardless of what the setback is, the distance between the corner of the building and the rear lot line of Miss Wynn's property at 504 Pequot on the site plan is indicated at 86.8 feet.
That's correct.
Okay. I'm just confused by the red line.
You're measuring this line off of that map.
Yeah.
But he's measuring 30 feet from the side to the red line.
Forgive me, I misinterpreted the point of your...
Yeah, I might have not drawn that red line into the residential district in this instance, but I would suggest that it still applies.
I see. Okay. Anyone else have any questions about this?
I just,
Please.
so, even though this is in two zones, it's still one property,
Yes.
right? So there's no requirements within the property.
No, not with respect to those types of setbacks. They're not
Well-
measured from that property, from that line. They're measured
Yeah.
from the lot line.
So,
I don't,
I'm fine.
okay. So, once again, we would suggest that the application does not meet the standards. As you know, the standards are set forth in Section 25 of the zoning regulations, and specifically, I would like to refer to 25.7.7, which talks about the site and establishing a transition in character between areas of unlike character to protect property values in the neighborhood, to preserve and enhance the appearance and beauty of the community, and to avoid undue traffic congestion. You've heard a lot from my clients about the traffic congestion that exists and the threat of a higher level of congestion by any further improvements on the site, where, once again, the on-site parking is inadequate to meet the present use. These standards have been found by the courts to be ones where that are required. They're ones that the commission must find in granting a special permit. And in fact, in the case of St. Joseph's High School versus the town of Trumbull, the appellate court ruled that these are essential findings that the commission must make. I would offer that the applicant has made its primary presentation to the commission. The applicant offered nothing on the issue of property values and preserving values in the neighborhood. You heard members of the public offer opinions on reduction of property values of their properties in the neighborhood. The applicant offered nothing from which the commission could make that finding on preserving and protecting property values in the neighborhood. On preserving and enhancing appearance and beauty of the community, you heard that there are sight lines which would be affected. In fact, you heard from residents of John Street tonight, and at the last hearing, you heard from residents of Station Street and Pequot Avenue regarding the impact of the project on their views and the appearance and the viewscape. And finally, again, it speaks to undue traffic congestion, and there can be no question that there's a significant traffic issue in that neighborhood, as you heard from so many of the residents. So on that basis, the Station Street Neighborhood Association would really urge this commission. And one other point is, once again, it's evident
from the email from the fire marshal and the new material and evidence that the required safety features that were, or requested safety features are ones that really cannot be accommodated. They were conditions that the applicant agreed to, but they're really conditions that cannot be imposed by this commission because they don't comply with the zoning regulations. And so for all these reasons, my clients respectfully urge this commission to deny this application. We certainly want to thank you for your generous patience and attention to this. And I don't know if does anyone have any questions at this point?
Commissioner Corcoran.
Mr. Green, could you clarify in terms of the certificate of zoning compliance from 2010? Are you suggesting that this does not run with the land and is not valid with regard to this
I would
business?
suggest that it's an expansion of that use and that variance, first of all, we don't have that variance, and it appears that it was conditioned on Sturm Ruger, but I could not find the actual variance and what it provides. I would suggest that there was a certain level of parking, there were existing buildings on the site, and I don't know the degree to which the certificate of zoning compliance that was granted in reliance on that did not have the existing parking configuration, nor was I able to find a document that established the current state of the parking as it exists on the site by way of a certificate of zoning compliance. And I would suggest that there's an expansion of that use.
Is it possible that it's relevant in terms of recognizing, or that it granted a variance for this type of business as being available on this property under the design business?
Well, it's not in the record and I couldn't find it.
Thanks.
Thank you.
Does anyone else have any other questions, Mr. Green? Okay. With that, thank you very
Thank
much.
you.
Are there any other members of the public that would like to be heard? Okay, going once, going twice. Very good. Mr. Fallon, rebuttal?
Thank you, Mr. Chairman. Good evening, everyone. For the record, my name is John Fallon. I'm here, as you know, representing the applicant. On behalf of the applicant and property owners, I want to thank the commission for your attention and for your diligence. I want to thank the members of the public for their courtesy. I think, as we always do in Fairfield, we can be on different sides of things, but when you come to Fairfield, everything is always civil and respectful, and I think that's a breath of fresh air. I think there's two major themes that I want to address tonight. I'll address momentarily what I consider technical issues, but I think the two major themes of what we're here to talk about tonight are very, very important to underlying zoning philosophy. One of them is, to what extent can perceptions, correct or incorrect perceptions, with regard to existing conditions, in this case involving parking and traffic, impact an application that conforms with the regulations and that will not exacerbate those perceived existing conditions. So that's number one of my themes for the evening. The second one, which is also fundamental, is what are the rights of property owners, be they residential or commercial property owners, to use their property in compliance and in reliance with the regulations, the zoning regulations that the commission promulgates. We all have rights, and zoning is contract zoning. It's an agreement. So when people buy property, if it's residential or commercial, they look to the zoning regulations to get some sense of what the use and enjoyment of their property can entail. And I think those two things are fundamental to your consideration of this application. And it is those that I want to succinctly, realizing you have other business, address. But before I do that, let me deal with the technical housekeeping. Section 12.7.6.4 provides that in a situation where you have the type of zoning situation we have, the setback has to be 10 feet or the same as that of the adjacent residential setback requirement, the adjacent residential setback requirement, whichever is greater. I'm not going to belabor this. You can go to your staff, you can go to your town attorney. This property is located in the A zone. This regulation, 12.7.6.4, is measured from the residential property. The property line in question of the church is a side yard setback. It is. And as such, you look to the A zone. The side yard requirements in the A zone are 7 feet. We're providing, in accordance with section 12.7.6.4, 10 feet. The commission looked at this carefully. You just had questions of Mr. Green. You have your staff, you have your town attorney, but I will tell you, for 42 years, we have always interpreted section 12.7.6.4 as the chair's question kind of inquired, by looking at the residential property. So that if the residential property, it's a rear yard setback to the residential property, then it's a rear yard setback. If it's a side yard setback to the residential property, it's a side yard. So that issue holds no water. The second thing that I wanted to talk about is the turnaround. Again, as I said before, this came about when the chief, even though we had a code enforcement review, and this is not meant critically of the chief is diligent in terms of his examination of site plans. Public safety is his concern for both his men and women and also members of the public. However, we did do a whole code review. These comments came from the chief yesterday. He was courteous enough to meet with us yesterday, and he asked us to just show him on a turnaround, show him on a sketch that we could make that turnaround. Mr. Green's considerations are misplaced. There is nothing in the zoning regulations that would prohibit us from complying with the chief's request to create a small grassed area where, in need of emergency, his vehicles can turn so they can go out without having to back all the way out on Station Street. The regulation that is applicable here is section 5.2.1. Section 5.2.1 is access in the residential districts. And what it says in pertinent part is, however, no walk or driveway shall be permitted giving access to any business or industrial use in the district. So what your zoning regulations say is if you have a split zone, you cannot use the residential portion of that property for access by way of a driveway to the business zone. That makes perfect sense, because you have to achieve your access to your commercial portion of your property via and over the commercial portion of the property. That's the section that you look to here, because when you cover a topic in your zoning regulations with specificity, you say, well, we're going to look at it. And in this situation, there is nothing at all that is a matter of public safety and complying with a request of the fire chief that would prevent you from being able to establish, as demonstrated on this sketch, a simple grass turnaround to be used solely in the event of a fire emergency. And again, I would defer to your town attorney and your staff on that, but I think that's accurate.
Why would you look to 5.2.1 about access? That this isn't about access?
Because it's the only restriction in terms of because it deals specifically with the topic of the utilization or not of residentially zoned property in conjunction with a commercial use.
The only regulation that deals with that circumstance?
The only regulation that would deal specifically with that, in my opinion, and does so specifically by saying you can't use residentially zoned property to, for want of a better word, access your commercial property.
You couldn't continue that area here to go down to Pequot, or, you know...
Right, but I don't think there's anything, and I'll leave it to you to review again with your staff, town attorney, whatever. There's nothing in the zoning regulations that would preclude compliance with a request from the fire chief in this instance to utilize the residential, a portion of the residentially zoned property, which we own, to show the chief that we can achieve a turnaround for his emergency vehicles.
Right, and I understand that, but are you not improving land in the residence zone to the benefit of the commercial use?
I don't think we are. I mean, if you consider that's a decision, as a public safety matter, the only thing we're doing here is we're adding those grass pavers.
Yeah,
Okay?
you are improving the land such that it can support the weight of a, whatever it is, a
Right, at the
44,000
specific request of the fire chief. And I don't think that is
to
in,
create a safe site plan.
to create a site plan that complies with the request of the fire chief. But
Right.
I don't believe that that in any way violates any provision of your regulations. You can consider it, you'll make that decision, but the reason I pointed out section 5.2.1 is I think the regulations speak very specifically to what you can and can't do relative to a residentially zoned portion of property in conjunction with a business use.
So,
Commissioner Noonan?
if you were not to comply with the fire marshal's request, would the site plan be compliant?
The site plan would be compliant, we'd have to go back to the fire chief, and we'd have to see if we could satisfy his concerns in some other manner, maybe by not putting in the grass pavers. But we're just trying to be, responsive to his request.
No, that's fine, I just want to...
But the answer is, your site plan would be compliant, but we'd still have an issue with the fire chief.
No, that's fine, I just wanted to know the baseline, so to speak, if you
Okay.
don't mind.
Yeah, I mean-
And as far as, you said there's no regulations that prohibit what you're doing with this turnaround.
Correct.
Is there a regulation that would allow for it?
I think
Explicitly.
by implication, if it's not prohibited, it would be allowed in this case to directly respond to a public safety consideration by the fire chief. I think you'd have to look to some manner, because what you're really getting down to is, and what I understand the chair's point being, well, you cannot use residentially zoned property for a commercial purpose. In its essence, that's the concern. But I submit to you that by accommodating the chief's request on our property for a safe turnaround, that doesn't fall within that prohibition.
Okay, but you look to 521 for your allowance?
I do.
Okay,
Yeah.
thank you.
And I appreciate that you've, because this is, first I'm looking at this, right? We just got
Right.
sketched, these issues are fresh, and we're kind of talking through these
Right.
issues, in the
Right.
first instance. If you needed additional parking, you would not be permitted to add additional parking spaces where we have this grassy
Absolutely.
turnaround. If you needed other things to satisfy the requirements, you would not be able,
Right.
be permitted to do that in this area, in the residential
Right.
space. One of the things that we are charged with determining is that the site plan is safe, and that,
Right.
right? I mean, that is expressly
Exactly.
is one of our, right?
Right.
And so the review from the fire marshal is, it is if, and only if, we have these conditions that the applicant has agreed to make. And I guess we are struggling with the notion that an improvement to accommodate these conditions that the fire marshal has requested is not utilizing the residentially zoned land
And-
for that commercial.
And I would
purpose.
suggest to you, and then I'll move on, but I would suggest to you that the distinction there, based upon, for example, the example you gave, is improvements. If you're trying to create parking and you were paving the parking, it's a pretty obvious case. In this case here, we are not doing anything other than using the grass area that's there now with reinforcement that no one will see.
I
If you
know,
consider that an improvement, I mean, that's something you're going to have to wrestle with. I mean, I'll be very honest with you, and again, it's not meant critically. This went through a total code review. And I do not believe, and I don't think the chief believes, although I don't mean to speak with him, that the site plan that is before you is out of compliance with the fire code. This is something the fire chief requested yesterday. And it's the spirit of my client and myself that you try to deal with it. I think it is not, doesn't create a zoning issue, and especially in the context of what is being suggested here. You're not really making physical improvements to the property. You're just assuming, you're just considering or assuring that the chief's request for a back area is protected. I will move on. Section,
Yes, Commissioner Corcoran.
I'm sorry, Commissioner
Question.
Corcoran.
I didn't realize. Go ahead.
So, again, looking at 5.2.1, why isn't a turnaround that's part of a driveway not part of the access?
Well, it's not part of a driveway. It's not part of the driveway, and it's not used to access the property. It's not a driveway, as the word is used. It's an emergency turnaround.
It's part of the egress for the fire station, fire truck.
It's not, but it's not a driveway.
Is it an
It's
egress?
going to be,
But it's not even an egress.
gonna have
just
structure.
No, it's not anything. It's not, it's,
peninsula of sorts onto the.
Well, I mean, I think, and if I'm putting words in your mouth, tell me I'm wrong, but, you know, the point is that the fire marshal wanted the improvement to support a fire truck so that the fire truck could have safe egress from the property.
over the driveway, which is already there.
Yeah, but in order
Mer-
to turn around,
But it's not part of, I would not say it's part of the driveway.
and that implicates, possibly implicates 5.2.1.
Man, that's why I said it.
We'll have to think about it.
All right, section 12.5, all right? Let's be very clear about this, and I don't even think we have to get into the whole discussion about Sturm Ruger or anything else. If you look at section 12.5, okay, you have a purpose clause at the very beginning. Most of your zoning regulations have a purpose clause. And in section 12.5, the purpose clause says, "The uses permitted in this zone shall be limited to those which primarily serve the local neighborhood and are consistent with the purpose for which this district was designed." That's your purpose clause. But then you get into your specific regulations. And your specific regulation in section 12.5.2 is, and I quote, "Business and professional offices which primarily provide services to customers and clients on the premises." Now, you have testimony from our client as to the fact that they do just that. They do provide services to customers and clients on the premises. There's nothing in section 12.5.2 that applies a local qualification. You could have done that. You still can. But it doesn't say, which primarily provides services to local customers and clients on the premises.
Yes, I understand.
And let me, if I just one other point on that, and it's a darn good thing it doesn't. Because that would be impossible to interpret or enforce. What is local? If somebody from Fairfield but not Southport, if somebody from Westport, if somebody from Easton, etc.
Why did you, as counsel for Sturm Ruger in 2010, seek a variance to this regulation for...
Because it clearly didn't fit the definition of section 12.5.2 as written, because it didn't provide services to customers and clients on the premises. It was a manufacturing entity. And
It was
an
not a
office.
business and professional office?
We didn't have customers coming and going from there. We didn't sell guns. We didn't do anything. It was a business office, but it was a business office without service to customers and clients on the premises. That's why I saw it, and that's why, with all due respect to Mr. Green, that whole scenario is irrelevant. And I was just going to get to that. Sturm Ruger, based upon what they did not meet the definition of section 12.5.2 because they did not provide services to customers and clients on the premises.
I see.
Okay?
And so
We do.
Ravis and Penfield presently
Do.
don't have a certificate of as a variance.
Never asked for one.
Variance for one of those.
Right.
Because your position is they do fit within the definition.
Right, and it's not only my position, it's your position. It's it's at least the department's position, because we've already issued zoning compliances to Penfield, and we've already issued zoning compliances to Ravis, and God forbid, we were to adopt Mr. Green's approach to this, because you'd have two problems. One, you'd have a plethora of businesses in Southport. I don't want to throw anybody under the bus, but they're all businesses which could be accused of not meeting this compliance definition if one assumes that there should be, in section 12.5.2, some assumed local qualification. It's crazy. It's absolutely crazy. And Sturm Ruger had nothing to do with it, because we didn't service, or weren't going to service, customers and clients on the premises. So I don't think there's any question that the use is permitted. And oh, by the way, you're approving a building. You're not approving, the use we've told you about, but we're asking you, and then, as a matter of compliance, the staff will have to determine if we're compliant, but I'm not hiding behind the issue, because Penfield Marine has already been found to be a permitted use in this zone, and you have testimony in the record to support that.
Mr. Fallon? if I'm
Yes, sir.
okay.
Yep, please.
On that same point,
Yes.
12.5.2, which you didn't complete, says, provided that no individual tenant shall have an interior floor area exceeding 4,000 square feet. Are they currently in one of the other buildings, and they're going to be vacating that and just occupying this, or is this in addition to what they already occupy?
It'd be in addition to what there are, no, this will be the whole building. I won't go there, thank you. But I do think it would apply on a per building basis, but it doesn't matter here, because
No, it's-
we'll be 3,400 square feet, okay? But thank you for asking that.
So there's a potential for another tenant in the other building. Never mind.
But it's got to be, the tenant has to get a
Right,
zoning
right.
compliance, and that has to be a permitted use. Let me, as long as we're talking about it, I don't want to jump around, but then I want to go...
Actually, I'm sorry, there was one other question related to that. 'Cause
Yeah.
you brought up the point that this does not specify the issue of it being local, but yet you opened with the purpose statement as being the
Yeah, but-
the end-all and be-all, and that says local. So
But your
how does
town
that
attorney-
when
your
does
town-
that disappear when you get to 12.5?
Because your town attorney could give you, I can tell you right now that there is a plethora of case law in Connecticut that says that a general aspirational statement in a zoning regulation does not apply where the zoning regulation and the commission then proceeds to address with specificity a particular use in the zone. And that's the point. The point is, yes, the aspiration statement says what it says, but when you get down to section 12.5.2, you didn't place in there primarily provide services to local customers and clients. And that's the difference. And that's why you have approved Ravis, that's why you've approved Penfield, and God forbid you didn't, because how would you ever manage that? What's local mean? Is it just Southport folk? Is it Fairfield okay? Well, not Westport, Easton, Norwalk? You're too far. I don't know. So I think you've defined the regs appropriately. Let me also, and then I'll be finished with the technical stuff. God bless Mr. Green, but I don't agree, I wish I could, with his statement with regard to section 25.3. I think when you read that again, the hour's late, staff will advise you. Section 25.3 does not stand for the proposition that abrogates your provisions in section 2 with regard to zoning compliances. A change of one permitted use to another permitted use in the zone requires an application to this commission for a zoning compliance. So all this business about how if you approve this business office use, which as you can see is a different use category, and then somebody wants to put a medical office in there, they can just go and do it, is nonsense. They'd have to file for a certificate of zoning compliance. They'd have to meet different parking standards, for one thing. So that's just, and section 25.3, I won't give you a dissertation, but that's not what it's talking about. Okay? So, let's get back to the general themes I articulated before. You heard testimony.
Commissioner Corcoran.
Yes, Commissioner.
I just want to go back to the local issue for a second. To me, when it says local, it means on the premises, as opposed to dealing with people on the phone from far away.
Right.
So for me, local, it doesn't matter whether they're from Easton or
Right.
wherever, as long as they come to the office.
Right.
That's serving a local
And-
client. But if you spend all your time on the phone
Right.
servicing somebody in another country, then that's not local.
Well, most businesses do both. They don't necessarily out in the country, and all I'm saying is, we comply with section 12.5.2. You've already found that because you've issued a zoning compliance for Penfield Marine in this zone. And you have the testimony of Mr. Brennan and Mr. Law telling you how they operate and that they regularly see clients on the premises. So I think
I
it's...
seem to remember only one or two Fairfield's clients. I don't remember.
Oh, no, they're not, I'm not saying they're Fairfield
No,
clients.
but I don't remember, and maybe it'd be helpful to have them come back up if they're here and available. I don't remember that being the case, that they primarily serve people coming into the office. I remember a lot of testimony about a few Fairfield residents. When people came in, they had to go to the Southport Hotel,
Yeah.
Delamar. So if they're here, I'd like to hear from them again, because that is not the recollection I have, and I will
Okay.
have to go back.
I'm happy to do that, and I'll have Mr. Brennan come up and just reiterate that. But again, I would point out, for this record, you've already found them to be a compliant business in this zone at this approximate location. But I respect your
Well,
request.
can you just go over that quickly, because I
Brennan,
don't remember that.
Can you talk about your...
I'm sorry, what's the question?
The question is how and when and if and so on and so forth, you see you see customers and clients on the premises.
We probably have people in our office daily, whether it's a ship agent, whether it's a ship owner, whether it's a ship broker, whether it's a charter. So I would say,
Travel,
to
I take it they're
Southport.
not from Fairfield or
No,
Fairfield County.
they come in
travel.
weekly,
But you have
if not daily.
Is it your testimony that you have customers and clients on the premises on a daily basis, more or less, as part of your business?
I would say 3 to 4 times a week, we'll have someone in our office visiting us. Absolutely, and probably multiple times a day.
Thank you.
3 to 4 times a week, people are coming to their office. And then what was the second?
And multiple, and many times, multiple times a day.
But are you telling me 3 to 4 times a week, and during those 3 or 4 times a week, there's multiple times per day?
So
Correct.
We'll have multiple visitors in one day.
Correct.
So that means about, just to go off of what you're saying, 12 times a week then? What is, I'm not following, 3 to 4 times a week,
I
I
would say
get
we
that.
probably have 6 to 8 visits a week.
Okay.
That would be rough numbers.
And people are traveling in
Yes.
generally for you, unless
Yes.
it's the business, the week, the month, yearly
Yes.
thing?
And then, as I said, and where we reference to Delamar, in October, and twice a year, we'll have customers come in where we'll have 20 to 30 people come in 1 week.
And do they come into your offices
They
as
come
well as
into
go to
our-
the Delamar?
Yes.
Thank you. Okay?
Okay.
Thank you.
And so just to clarify on the point where that you've made that, we have already granted a zoning compliance to Penfield for their current office. That was over the counter, right?
I assume?
Through the zoning office, based upon the submissions that you make in that circumstance. That was not before our commission.
I can't speak to that.
for
I
specific
think you're
approval.
probably right, but I defer to staff on that.
Okay.
Okay.
Come to a public hearing.
That, I don't know that, but that's something staff can tell you. I don't know. I mean, I don't know, for example, whether that was part of your 2011 review for the special permit of this whole site. That's something you'd have to check with staff. But I think the important point I'll leave you with, and then I'll leave this, is that the regulation, the regulation that is in effect does not establish a local qualification to the customers and services. And number two, you have the testimony you have that they do provide those services on premises, which they've been doing for many years in this zone, and you are all familiar with the zone. And if we set a standard here now that's going to be rigid in your application of section 12.5.2, I would suggest 2 things. One, you jeopardize the quiet enjoyment of a lot of owners and tenants in that zone, and you also, I think, send an unfortunate message in terms of economic development, by the way, the Economic Development Commission having supported this application for that Southport area. Okay, the general themes I talked about. Let's talk about traffic first. you know, we heard some fairly dramatic testimony how Southport is being choked by cars and we can't stand the impact of more cars. I think this commission has made wise and judicious and proper planning decisions over the last decade with regard to the entire town of Fairfield, including Southport. And I think the town has benefited from that. So I don't subscribe to the assumption that somehow you have allowed Southport to be overdeveloped. I don't think that's the case at all. I think it's a charming, vibrant business center, and its success and charm and attractiveness has a lot to do with your stewardship. Mr. Galante's findings, I believe, are uncontroverted. And at the end of the day, what you have before you is an increase in peak volumes associated with this 3,400 square foot office building of 4 vehicles per hour. So I would say to you, whatever the merits or not of the concerns about existing traffic, we have and will have no adverse impact with regard to any existing conditions, be they acceptable or not. And therefore, it's not a basis for denial of this application. Similarly with parking. Mr. Galante's parking analysis was comprehensive and very professional. Mr. Green misstates that he comes up that we are deficient in parking by 1 space. Number one, we comply totally with your regulations with regard to parking for both the proposed building and the new building. What Mr. Galante's report says is that for a 1-hour period, I believe it's on a Wednesday, there's a 1-hour deficiency, a one space deficiency that could be resolved by the Philippone real estate people agreeing to move their meeting, their weekly brokers meeting, I think it's from 11:30 to 10:30. And you have a letter, an email from Mr. Philippone, and you have a commitment in this record from the applicant that that can be a condition of approval. So we're not deficient in 1 space. We comply with your parking regulations. And to the extent that we went out of the way to do a observed parking analysis, it demonstrates that overall, except for 1 hour on a Wednesday, we have more than sufficient spaces. And for that 1 hour on Wednesday, we're short 1, and we've dealt with that and how to mitigate it. You know, you had a lot of photos submitted, and I'm not going to go through them, that big pack of photos. I'm sure I see that most of the commissioners have them. Well, to me, when you go home prior to your deliberations and look at it, all they really demonstrate is that people, during the hours noted on the photographs, are legally parking in legal on-street parking spaces. But I have to leave you, and I'm not trying to be critical, but there's one photo in there that was taken on August 27th at about 2:30 p.m. My clients were concerned because they perceived that there might be a parade or something going on because all of a sudden all these vehicles showed up on their street. One gentleman was seen to bring 3 cars. Somebody got out of the car, pictures were taken, and at 2:37, you can match this up, that's what the street looked like. Be that as it may. Those pictures only demonstrate people are parking legally. But again, it gets back to one of my first themes.
Do you really dispute that people park illegally on Station Street adjacent to the restaurant?
From time to time, and those are demonstrated in the picture, mostly in evening hours. But again, my point is the Galante parking study demonstrates that, and it gets back to one of my first themes, and that is, if there is an on-street parking problem, which I don't believe there is, but if there is, we're not going to exacerbate it based upon the Galante study. Then we get to some specific comments. You know, the other thing I talked about is trying to balance the rights of property owners in situations like this, where residential property borders commercial zones. I think it's worthy of emphasis that my client really has, and I think the neighbors have said as much, and tried very much to be a good neighbor. He has approached this property as a very sensitive steward. His 2011 improvements were sensitive to the historic nature of the property, and its good neighborliness goes on and on. I mean, we've heard from a number of people, all fine people here. Ms. Plant, we tore down our fence so that she could access her property when she was repairing it. We've allowed Mrs. Shaw to plant on our property to enhance her property. I think we've addressed some concerns from time to time of Ms. Estelle with regard to removal of trees. We always allow the church to park in our parking lot when they need it for special purposes. We've changed the garbage pickup times, et cetera, at the request of the neighbors. All of that, in terms of neighborliness, I think is reflected in the history of this application. We originally proposed a 4,933 square foot building. After meeting with the neighbors and hearing their concerns, we reduced that to 3,560 square feet. And now the application before you is 3,440 square feet. So since we started this process in October, as evidence to the fact that we are trying to be good neighbors, we've reduced the request by 1,493 square feet, over 30%, so that we're left with the building that we're left with. And I think a number of neighbor comments, and I mean this in no disrespect, really get to the essence of my concerns about that second theme I addressed. I heard one speaker talk about the fact that our building is approximately 21 feet tall, and that the topo of her lot made that seem large or impressive. Well, first of all, our building complies with all of your requirements with regard to height, FAR, coverage, and setbacks. Indeed, we lowered the height of the building to address some of the very comments you heard tonight about protecting the view of the church. And I think it's, again, worthy of recollection that we're proposing not only a building of the size I talked about, but one where the height is approximately 21 feet in a zone that allows 30 feet. Post-development of this small building, our total coverage will be 25.8%. The zone allows almost 3 times that much, 75%. And the FAR will be 31.4% in a zone that allows 100%. Someone said, and this gets to the heart of my concern, and I think I'm quoting, "The building is beautiful. It looks like a residence, but the problem is it's a commercial building." Yes, it's a commercial building because it's in a commercial zone. And that is, intentionally or not, the kind of classic NIMBY sentiment. People bought their homes, some of them quite recently, adjacent to this commercially zoned piece of property.
But it's not commercially zoned. It's a neighborhood business design district.
It's
a residence zone.
It's a neighborhood design, it's a business zone, and they bought their property adjacent to it, and now they're suggesting we don't want to see it developed in the way that your very regulations allow it to be developed. And I think that's problematic. And I think there should be a proper balance. And in this case, I would suggest to you, Mr. Charney and Mr. Finley have shown an overwhelming ability to try to balance it fairly. The building is now down to 3,400 square feet, et cetera, et cetera, et cetera. But there comes a time someone says, well, we're trying to, and I think I quote, squeeze in another office building. We're not squeezing in everything. Look at the coverage in FAR and setback compliance that I just talked about. We are tastefully and conservatively seeking to have a building approved well within the basis of your promulgated regulations. And as somebody else said, rules and regulations in place, yes, they are. And all we are asking, that's exactly the point, that those regulations be applied even-handedly, and that we be allowed reasonably to utilize our property in accordance with the regulations, especially when there is nothing in the evidence that would indicate that we're going to have any exacerbating effect on any condition relative to traffic or parking. So it's not, as Mr. Green says, development to the max. It's a very understated proposal, and one that, in fact, I think is very fairly and reasonably before you. So in conclusion, I think there are, the technical issues are not well-founded. Your regulations establish that this use is permitted. This use as to the specific tenant is there now and has been for numerous years. The evidence is in the record with regard to that. The whole question about the setback is misplaced because it is a side yard and we comply. I commend our efforts to address the 11th hour comments of the chief in a positive way. I don't think that that very limited acquiescence to his desires in any way creates any violation of your zoning regulations. But at the end of the day, this is about fairness. Fairness to everybody. Everybody should be entitled to enjoy their property. They should be entitled to have reasonable expectations that they can utilize their property in accordance with the zoning regulations that exist. And as long as the property owner has demonstrated that they are sensitive to that, then I think it's incumbent on the commission to keep in mind. For example, we heard a lot of questions I just wanted to mention about property values. Well, there's case law that I think this commission is familiar with that says that if the use is permitted, there is a presumption that it will not have adverse impact on surrounding property values. And there is always a sensitivity and attention when you're dealing with property like this, where you have residential property abutting commercially zoned property. And what you need to do, I would respectfully suggest, is look to your regulations to fairly balance the rights and protections of the property owners against the rights and reasonable protection of the commercial property owner. And if you do that here, I would respectfully suggest that with a 3,400 square foot building generating 4 parking spaces, four vehicle trips during peak hours, compliant with your regulations, including parking, the fair balance here is approval of the application so that Mr. Charney and Mr. Findlay can continue to maintain it with the sensitivity to its historic location, its historic past, but at the same time see that it maintains the being part of the vibrancy that everyone in Southport desires and can be proud of. So I appreciate your attention.
Very good. Thank you very much, Mr. Fallon. With that, I'll close the public hearing on this item. Next is 54 Sasko Hill Road, special permit application and coastal site plan application of Sasko 54 LLC pertaining to a mixed-use commercial and residential building in the design commercial district. We'll just take 2 minutes to allow setup and people to do their thing. The meeting back to order. Stage is yours.
Mr. Chairman, members of the commission, for the record, my name is Bill Fitzpatrick. I'm an attorney in Fairfield with the law firm of Fitzpatrick, Frey & Bologna. We have offices at 1735 Post Road. I'm here this evening representing the applicant, Sasko 54 LLC. The owner of the premises located at 54 Sasko Hill Road. The principal of Sasko 54 is Mr. Jack Roberts. Jack Roberts is here today with me. Jack Roberts and his company, Tankship, operated out of 54 Sasko Hill for years until they outgrew the space. The building at 54 Sasko Hill was significantly damaged by Superstorm Sandy and has not been occupied from that day forward. Any new construction on the property must conform to appropriate FEMA standards. The property at 54 Saskell Hill Road contains 12,430 gross square feet with a net square footage of 8,290 square feet. Property is located in the Design Commercial District. It is subject to an easement in favor of the property to the south, that's the residential property, for access to their garage. There were two earlier applications to this commission relative to this property made by a contract purchaser of the property. The first was for a mixed-use building. That application included a design which many, including the neighborhood, found remarkably unappealing. That application was withdrawn after the public hearing but prior to any decision. Subsequently, an application was filed with the commission, again by the contract purchaser, to change the zone of the property from design commercial to Residence A and to construct a single-family home. That application was opposed by the owner of 10 Saskell Hill Road, commercial building which abuts the property on the north. That property fronts on the post road as well. And subsequently, this commission denied that application for a change of zone and then obviously denied anything to do with the residential construction because it was no longer permitted in the zone. So at this point, the zone of the property is designed commercial. The application before the commission is a special permit application for construction of a mixed-use building as well as a CAM application pertaining to the same construction. The proposed mixed-use building, consisting of a first floor of, one floor of office use and a second floor above of a two-bedroom apartment, is a permitted use in the existing design commercial district, subject to special permit approval by the commission. The presentation to be made tonight will include Jimmy Zumo on behalf of Land Surveying Services, LLC, which is a surveying and engineering firm with offices in Fairfield. William Kenny of William Kenny Associates will address the CAM application, as well as the proposed landscaping and including the improvements to be made adjacent to the mill pond. Jack Franzen and John Stevens of J.P. Franzen Associates Architects PC, an architectural firm with offices in Fairfield, will address the building design, building floor plans, site lighting, etc., and other issues relating to the building. Mike Galante of Frederick P. Clark Associates will then address traffic issues, and I will then conclude. To offer a brief preliminary look at the proposal, this is a proposed mixed-use building. The proposed lower level will contain 2 parking spaces under the building, as well as an entry to access the elevator. The next level of the building will be designated for office tenant use. The upper level plan will include a 2-bedroom apartment, and the attic will include a crawl space and mechanical units servicing both the office and the residential use. I should note that revised plans were submitted that show a movement of the building to the north about 3.5 feet and the inclusion of an open access way porch area that Jack Franzen can describe. The intent was to gain some flexibility on the issue of height. This revision is essentially a minor movement of the building to the north. The building exterior, with the exception of this little porch area, remains the same. Floor plans are the same. Site parking layout's the same. Site drainage is the same. It was simply our effort to gain some flexibility in dealing with height. I can address that issue in more detail if the commission so desires. At this point, Mr. Chairman, I'd like to introduce Mr. Jimmy Zumo from Land Surveying Services to discuss the site and the site plan. Jimmy.
Good evening, everybody. Mr. Chairman, the members of the board. My name is James Zumo. I work at Land Surveying Services directly under Neil Jane. He is a licensed professional land surveyor. I'm sure a lot of you know Neil. He's been a fixture of the community for about 25 years now. We'll start off with the existing conditions. If you look, I know you guys all have that in your sheet set. I believe it's the first sheet after the title page. And this is basically showing you exactly as the lot sits right now. After Superstorm Sandy hit and essentially rendered the building unusable, it's gone unchanged. As Bill had mentioned previously, the gross lot area of the building is 12,430 square feet, and due to some irregular shape at the front portion of the building, front portion of the property, most of that area is taken out. About 4,000 square feet of that's taken out for that portion. In the regulation, as it states, half that area, half the minimum square on the lot, you must remove that area from the lot area. And then you have the 1-year title line at the Mill Pond section of the property towards the west. Those two areas taken out bring us down to our net lot area of about 8,290 square feet, which is what we are basing all of our regulations off of, all of our percentages, and for the proposed building and existing. The lot is gently sloping. There's no major topography on the lot. It gently slopes from the east to the west, starting with an elevation of about 13 up by the road, and sloping down to 3 down by the river area. The property line is set at elevation 11.2 as per regulation, the mean high water line. So that's where the property essentially stops, and that's basically right at where, the water is hitting, right in that general area. The easement is located up in the front. If you could see, it kind of looks like an elbow macaroni right in the front, which gives access to this building, to the south. They use that to get in and out of their garage and to use as their parking area. Existing conditions-wise, that's pretty much it. It's just been a pretty stagnant lot for the past 6 years.
I have a question.
Yep.
Where's the driveway access to the existing building?
The driveway access to the existing building starts over here, right above where it says road, and it flows all the way towards and it just goes all the way up in a regular shape. It kind of arcs out, then comes back in, and then hits some gravel, and then hits the building.
Is it shown on the,
It's shown by the dash line.
that's one side of it?
That's one side of it. The other side of it, as you can see, flows into the neighboring property. It almost follows that elbow, and then it hits the property line, and that's where it then goes into the neighboring
Oh,
property.
no, I don't mean that. I mean the access to the existing building.
This building,
Yeah.
straight from the front here.
Where is it?
Right at the base, right at the road, right above where it says road, there's an entryway. It's about a 14-foot
Sorry,
wide.
Can you drive to the existing building?
Absolutely, yes.
Where?
From here to there.
So that whole area in front of it is paved?
It's paved and gravel.
It's like one huge park.
It's one huge parking area.
So it's this.
Yeah, it's basically the entire front portion of the property.
No, it's not that. Oh, yeah, that's the paved part.
That dash line and then this dash line.
Yeah.
It's this whole zone.
No, because he shows bituminous on the other side of that dash line. See, it says bituminous. So
Yeah, the
every-
entire front portion of the property is pretty much used as access to it. There's gravel portions and there's bituminous portions. There's nothing per se that's grass.
Okay, that was my question.
Yeah.
Thank you.
Yeah, it's pretty much all covered. Is there any other questions regarding existing conditions? All right, so the next page, which I believe is the third page of your sheet set, is the proposed improvements to the lot. As you can see, we have the building is situated towards the back of the lot, almost in the general same location of where the building is right now. We're not trying to, we're not trying to move this building forward. We really can't due to the shape of the lot, and that is that is the flattest area of the lot where we could start to work, and you could start to, keep everything the same. It is a FEMA lot. It's a flood zone. You got to make sure that you're keeping this lot as pristine as possible. Make sure that you're not adjusting or messing with any of the grades, drastically so that you're affecting other properties. We are not going to be affecting the easement for the neighboring property. We are going to be putting a curb in fact, so that, along that easement, so that that easement is clearly delineated, and we will be landscaping that top left-hand corner of the property, the southeastern most portion of that property.
That's that green curve.
That's that green curb. That green line is the curb, is going to be the new curb line along the existing easement. We will be utilizing the entire lot, or the entire front portion of the lot for parking. Regulations state for parking, we need to have, 10 parking spaces for the building. That's including the office space, and that's including the residential. We have 2 parking spaces inside of the building, and then the 8 other spaces will be located on the outside of the building with 1 handicap space closest to the building. There'll be a handicap ramp that will be on a retaining wall to allow for the access of the handicap ramp up to the lobby level. Lobby level will be set at elevation 11.1, so it'll be 1.1 feet above the FEMA flood zone, which is 10 in this zone. And from there, they will be able to access the elevator and stairs and anything to get to the office level and the residential level.
The plan seems to show 11 spaces, is that correct? It shows 9 outside of 2.
You're correct. Yes, that is correct. It's 11 spaces, 2 inside and 9 outside. There is an existing utility pole on site that will be relocated to adjust for the parking. That utility pole is in a peculiar space. We'll be coordinating with UI during construction to move that pole so that we could get all those spaces in there as best fit the lot.
How does that retaining wall with parking on top work?
So the retaining wall is going to be underneath the parking. It'll be just a standard 1 foot high. It's about 1 to 2 feet high. The the retaining wall will be laid, then the parking will be laid on top of that, and it'll have curb stops on top.
So there's like a swale going around the outside of it, down to the, because it looks like the other side is uphill, so I don't understand why it's...
So the neighboring lot does go uphill. But at that point, where we need to get that elevation of the parking lot so that we have an ADA compliant ramp, we need to have that elevation up a little bit higher than what's at that position currently. So that retaining wall is there so that we could get that ramp started without it being too steep to get a wheelchair up. There'll be parking spaces for bikes on the southern portion of the property, right in front of right in the front left-hand side of the building, along with an enclosure for a dumpster. And the existing building is already utilizing a sewer lateral connection. We'll be utilizing that same exact connection for all sewage and everything to go into the town's sewage system. Grading will be kept to a bare minimum on site. There will be a couple contours set in the middle of the parking lot, which you will be able to see on the next sheet why those 2 contours are being graded into that section, and that all has to do with the drainage so that we can mitigate all the stormwater detention on site. Is there any questions on this portion of it? So we'll switch over to the next sheet. All right, this is sheet 3. Now, this is all the engineering work that went into mitigating all the stormwater management on the site. There are essentially 5 portions of this site that will allow for stormwater to re-enter the ground without causing any adverse effects on any of the neighboring properties. If you look towards the eastern portion of the property, about 1/4 of the way down, you will see a trench drain and a catch basin there. That trench drain and catch basin will outlet into a stone bed underneath of the driveway, the proposed driveway. With that outlet, whatever water can will infiltrate into the ground from that portion. There's an outlet control structure to the south of that. That outlet control structure will allow for water to fill into that when it starts to overflow and at a specified rate go into the next system. That's SMS number 2. That's about halfway down the lot. If you look at SMS number 2, that's concrete galleries. Those concrete galleries are there again to infiltrate the water as much as possible. There is another catch basin and trench drain there, so that that could catch any water that is being missed by this trench drain and catch basin. From there, the same thing happens to get to the next system. And there is where you're in, I'm sorry, those two contours, that minimum grading that we were talking about is right in the middle of the site there. Those two contours are set there so that the water will hit that catch basin and that trench drain, and the water will get into that as much as possible and get into that system. Same thing happens with the third system. Another stone bed, the same as the stone bed as up above, a little bit larger, but essentially the same system. After all else fails there, it goes out, and then it goes into this water quality swale. Bill Kenny will be talking about that water quality swale later on. He designed a nice planting plan for all that, and then there, that's essentially getting the water back into the ground again. And from there, God forbid the water goes over that, there is a level lip spreader. All that level lip spreader is that is set as a specific elevation. The water will go up to that point, roll over, go into some river rock or, crushed stone, and just dissipate into the ground again. So essentially, you're hitting, like I said, 5 points of infiltration into the ground to mitigate as much as the stormwater that's running off this site. We got a letter from Laura Pooley. I think that is all in your file. She is in agreement with all stormwater mitigation out here. She agrees with the drainage report provided by our engineer, and she is, and that is good through the 100-year storm. That's good through the big storms. Is there any questions on the engineering? Nothing? And the final page? The final page is just erosion control. These are our erosion control measures put into place to make sure that, one, we're not tracking mud all the way up and down Sasco Hill Road. We all know how beautiful that road is and all those houses there. They don't want to be seeing mud up and down their road. The anti-track apron is there to set that, make sure all those truck tires that are coming in during construction, in and out, that as much of that mud is coming off and it's getting sucked back into those rocks, and then when it rains, it goes back into the ground. And then silt fences. Silt fences are set around the entire perimeter of the property up to the coastal jurisdiction line. At that coastal jurisdiction line, we will have the silt fences will be reinforced with hay bales to further prevent any sediment flowing into the mill pond. We're going to mitigate as much as that silt, there's going to be silt, made from all of this, construction. We're going to try to stop all of that as much as possible and as our best ability from getting into the mill pond and getting out into Sasco Hill Road, Sasco Hill Road. Any questions with that? All right. Well, I conclude all my stuff.
Thank you very much.
Thank you, Jim. Mr. Chairman, I'd now like to introduce Mr. William Kenny of William Kenny Associates, LLC, a soil scientist, a professional wetland scientist, and a landscape architect with offices in Fairfield.
Good evening. I'm Bill Kenny, principal of William Kenny Associates, registered landscape architect, wetlands scientist, and soil scientist. We were retained on this project to first identify and assess the coastal resources that are on and adjacent to the property, then to assist with the project design to ensure that there wouldn't be any impacts to those resources, and actually then get involved with the design as well with regard to preparing a planting plan for the project. And based on all that work, and in summary, before I get into my presentation, our conclusion is that there will not be adverse impacts to the coastal resources, and that the project is in compliance with the coastal, the state's, the Coastal Area Management Act, the policies of that act. So, existing conditions on the property, it's approximately 2/10 of an acre. We have Sasco Hill Road on the east, the mill pond on the west. The property is about a mile from the Long Island Sound at the mouth of the Mill River. This is an impounded section of the river. You have the dam just downstream. So that means at low tide, all the water doesn't go out. But high tide, it comes up above the river. And so this is a tidal section, and therefore The river is a tidal watercourse. Adjacent to that are some tidal wetlands that we identified on the site. We did not find any inland wetlands on the property, and I know the town conservation department agrees with that conclusion. On this drawing, the tidal wetlands are shown here in the mustard color. This lighter green in the center of the property is the coastal hazard area, or otherwise known as the 100-year floodplain zone. And lastly, you have what's considered a shoreland. It's land that's uphill of the flood zone. So the primary coastal resources on the property are the tidal wetlands and the mill pond. So our focus has been on to protect those resources. And you can see this shows the existing building here, and this line is the edge of pavement. So it shows how the existing pavement extends from the road to the building. Also, a critical piece of existing conditions is that there are no stormwater management features to protect water quality or water quantity to deal with flooding. So, proposed conditions. Some of the key features are no structures or pavement or development is being proposed within the critical coastal resources. The tidal wetlands, nothing's occurring within that area except to improve that habitat area. And the work that's occurring within the coastal flood hazard area is being done in accordance with FEMA regulations, and that's both the site engineering and the architecture is designed in a way to comply with all those FEMA regulations. The proposed building is generally, the footprint is generally the same as the existing building and close to the same location as the existing building. As has been discussed, there's been a large effort and there will be a lot of expense to go into managing stormwater on the property, both in the short term during construction for soil erosion and sediment controls, and after construction with all of the infiltration devices, the collection system to collect stormwater runoff, and then to hold it below ground and allow it to infiltrate into the ground. And if the capacity of that subsurface system is exceeded, which there's always a storm larger than your system, that it allows for an overflow through the rain garden or water quality swale that's on the south side of the building, and that swale is going to be planted with native plants, a meadow planting to allow to filter the water, slow the rate of water flow down, and allow more water to be infiltrated into the ground. The proposed landscape plantings, all the plants that we're proposing are native plants to the northeast. 2, we're complying with the town regulations, section 25.7.6, with regard to suitable landscaping in areas that are not otherwise building or pavement. Although we have less than 20 parking spaces, section 28.11.3 requires you have 1 tree for every 10 spaces, but it doesn't apply to this lot. But even though we still have 3 trees that we're proposing in and adjacent to the parking, so we're exceeding that standard, although it doesn't apply. And then lastly, the planting on the west end of the site with regard to the tidal wetlands. And I forgot to mention under existing conditions, that wetland area is degraded due to past use. A portion of it has been maintained as lawn, although not a great lawn. It was mown, and so it doesn't have a lot of habitat value in its current condition. And another portion of it is being dominated by Phragmites invasive plant. So we're calling to eliminate the lawn, remove the Phragmites, and come in and plant it with all native tidal wetland plants. That would be in this area here, and then in addition, all the way up back to the building and to the parking lot, it would again be native plants, native shrubs, and herbaceous plants. There are the herbaceous plants, or the meadow plants, they'll all be rooted plants. It's not going to be a seed mix. There's about 1,000 plants that'll be installed in that area to cover that area and make sure it's nice and densely vegetated. So with all of those proposed improvements, And based on the existing conditions, that's the basis for our conclusion that this project will not adversely affect the coastal resources and that the project is in compliance with the state coastal resource policies. You're welcome, thanks.
Yeah, I have a question.
Question right here.
So, looking at the plantings next to the road, it shows large shade trees, and then it shows plantings underneath them.
Yes.
How do they get light?
So we're using shrubs that would grow in a woodland, so they are accustomed to dappled shade, and so the shrubs that are shade tolerant, that have a higher tolerance for shade.
Thank you.
You're welcome.
Thank you, Bill. Mr. Chairman, I'd just like to note that, to follow up on Bill's presentation, there is a note in your file from Crystal Kallenberg to Emmeline Harrigan dated April 9, 2018. Emmeline, thank you. Thanks for your help on this. We have no objections to this proposal. And Crystal is with DEEP. Mr. Chairman, I'd now like to introduce Mr. Jack Franzen from J.P. Franzen Associates Architects, P.C., well-known architect with offices in Fairfield. Jack.
Good evening. I'm Jack Franzen. I'm the architect for the project. I'm here with the project architect from my firm also, John Stevens. And I live in Fairfield on Congress Street. My office is at the Brick Walk. But I also have an office that I've maintained at the Tide Mill building, and my main office was there for over 30 years. So I'm very familiar with this area, and actually had to evacuate my office 3 times while I was there. 1992, we had an amazing storm. It was a no-name storm, but it was over a foot of water. And then we had Irene, which actually was less than that no-name storm. And then we had Sandy, in which case we were out of electricity and power for a very extended period of time. Our proposal, as everyone has explained, is to build a new structure consisting of a new mixed-use office and residential building. It's on the site, more or less the same footprint as the existing building. When I moved to Southport, there was a doctor's office there, even before Mr. Roberts took position and had his business there. The site is located in the design commercial zone, and it's abutting the A residential zone, and it's also in the AE10 flood zone. And as you probably know, the A zones, the A flood zones is where the water comes up. There's no wave action, but when there's a flood, the water just keeps coming up, and then it subsides. And I'll go into that in more detail, why we designed the building we did to accommodate the occasional flooding. The parcel is about 250 feet deep. It runs east-west from Sasco Hill Road to the Tide Mill Pond, and it's a varying width, more or less of an hourglass shape. I think it's around 57 feet at its widest and 36 feet at its narrowest. The site plan being proposed places the new structure where the old one was, and it's set back from the coastal jurisdiction line, which is this line right here, this dotted line. About 2.5 feet is as close as we get, and it gets farther away because it's a curved line. We are proposing a 0 setback on the north line because there's a partially enclosed pedestrian entry that is accessed by the accessible ramp. And that leaves us with about 15 feet on the south side of the property. And our building is about 150 feet from, depending on how you measure it, because the road's at a slight angle, from Sasko Hill Road. As Jimmy explained, the on-site drainage is provided by means of surface drains connected to an underground retention system located beneath the parking field. Also by means of a rain garden that Bill Kenny described on the southerly side yard, which is this more or less oval area here. There is a recycling area that's enclosed by a fence on the southeast corner of the building, that rectangle here. And as Jimmy explained also, and there are 11 car spaces by town standards. We need 2 for the dwelling and the 9 other spaces for the office use. The space closest to the building is the accessible space right here. There are 4 90-degree spaces, and the remainder of the uncovered spaces are parallel spaces. We also have a bike storage rack that's provided just east of the rain garden, right here. Pedestrian circulation on the site is from the parking field, depending on what car you're in, you walk across the parking field and use the accessible parking access area as means of entering either the ramp on the north side of the building here, or the set of steps that lead up to the portico or the main facade of the building. I have 11 by 17 copies of the rendering here that you can pass around. The commercial regs for the zone allow us to have this mixed use, and I think it's appropriate as a transitional use between the office building that's existing on the post road to the north and the single-family home immediately to the south. The building that we've designed has overall dimensions of 37.5 feet roughly by 47.5 feet. In addition, there's a 10-foot open deck on the west side. You can't see that on the rendering because it's on the west side, but that's the open deck. I also mentioned that there's a ramp on the north side that's a handicap ramp that accesses the side entrance. The building in height is 38.9 feet, and that includes the lower garage area that does not count as a story. And the height calculation is not taking advantage of the Section 12. There's a so-called bonus provision for extra height if you're in a flood zone, and the 38.9 feet is not taking that into account. So we meet, I think the maximum is 40 feet, so we're well below the 40 feet. If we took the bonus, we'd be even more so. As I mentioned, the building has 3 levels. On grade, at around elevation 7.5, is the 2-car garage. And behind that, there's an open lattice area for water to come and go into the building. Above that 7.5 elevation, inside the building, there's a, you can see here, there's a landing, and that landing is at 11.1. It can't really be much lower than that because it has to comply with FEMA. That's where our elevator stops. and can't be much higher because the handicap ramp wouldn't work, the slope wouldn't comply. So it's calibrated to that. The first real, floor of the building is the office level, which is this level here. And above that is the residential floor. As was explained, it contains a two-bedroom apartment. And in accordance with the design commercial regs, the residential use does not exceed the 50% of the building area. Mechanicals for the building are located in a recessed there's a recessed rooftop mechanical field and screened by a parapet. So the actual surface where the mechanicals are is on top of the ceiling of the apartment, and there's scuppers there, and there's an access door into the crawl space of the attic. Other mechanicals such as ductwork and vents are located in that crawl space, and it's accessed by a staircase. There's no living space, no habitable space in the attic. The design of the building is traditional, New England vernacular architecture, and it consists of materials which I have some boards to show you. The lower level garage area has a board and batten siding, which is what you see there. The main habitable levels are shingle, wood shingle siding with about a 6-inch exposure. The roof will be 30-year asphalt shingles. The trim will either be painted wood or cellular PVC, which is commonly known as AZAC, and the windows will be double-hung windows. They'll be clad windows with divided lights. The exterior lighting for the property consists of, go back to the site plan. The exterior lighting for the property consists of 2 post-mounted lanterns and 2 building-mounted wall lights. One of the posts will be on the south side of the driveway closest to Sasko Hill Road, and the other will be located on the north side of the parking area near the north property line. The 2 wall lights are to be located one above each garage door. The photometric chart here that I'm showing you, and you can see these values on the north and the south, demonstrate that we are in compliance with regulations, that there's minimal light spillage onto adjacent property. We believe the building is compatible with the surrounding neighborhood, and that the mass that I've described, the 37 by 47 foot mass, is consistent with the scale of other buildings and homes around the mill pond. And while the subject property is not a part of the Southport Historic District, it is visible from the same. So I think the diminutive scale of the building is important. We've designed the building with materials and fenestration that are in keeping with the mostly 19th and 20th century homes that you can see from the pond or from the surrounding roads as you drive around the mill pond. It should also be noted that there have been a couple other proposals over the last several years. And I think one of the problems with them was the building didn't look, that was being proposed, didn't look anything like anything else on the mill pond, let alone anything that you'd see in the historic district. So we really have tried to work on that. In summation, I think we have proposed an attractive building, and I think it'll form appropriate transition between the 2 zones. The building does favor the northerly property line, giving as much breathing room to the dwelling on the south as possible. And we do comply with all the applicable regs. As Jimmy said, there's a letter from engineering that our engineering plan is good. There's nothing non-conforming about this project. Mixed uses have complementary parking demands, and I can tell you they do because where I am now in the Brick Walk, our building has 2 apartments, and other than the restaurant uses in the Brick Walk, the office and residential uses they just mesh perfectly, because when I'm leaving, Nancy and the lady who's above me comes in, and we actually sometimes use each other's parking spaces. So I think the parking usage works really well in a situation like that. I'm going to stick around. I'm going to turn it back to Bill, and I'll be available for any questions that you might have. Thank you.
Thank you, Jack. Mr. Chairman, at this point, I'd like to introduce Mr. Michael Galante of Frederick P. Clark Associates of Rye, New York, and Fairfield, Connecticut.
Good evening, Mike Galante, Frederick Clark Associates, Principal and Traffic Consultant for the applicant. I'm just going to run through briefly my July 13, 2018 traffic evaluation letter. And I say traffic evaluation letter because it's not a full traffic study. This type of development, this amount of traffic generation doesn't lead up to a full traffic study with analyses and so on. Just briefly, the site, of course, as you know, is located on Sasco Hill Road. Oh, yes.
Do we have anything from you in the record?
We do. This was actually submitted for a June or July meeting. It was,
Oh, that's right.
It was postponed until now, so it wasn't in this last packet.
Gotcha. I apologize.
Okay. If you need it, I have it electronically that I can forward.
Yep, that would be good.
And I'll give you a little bit more detail, since you may not have it.
Right.
Okay. In the report, the letter report itself, obviously the project itself, the description, there's an existing but vacant office building there today, approximately 2,300 square feet of space. The proposal is to replace it with about the same amount of square footage for an office use plus 1 residence on the top. So that's virtually the difference between what's there today and the future. It's 1 resident, 1 unit that's not there today. Roads, it's located on Sasco Hill Road, about 200 feet south of Post Road, signalized intersection. Post Road in that section is actually a 3-lane road. Posted speed limit is about 35 miles per hour, and the hourly peak hour volumes were about 1,500 vehicles. Clearly directional peaks in the morning towards Norwalk, if you will, in the afternoon towards Bridgeport, as all commuters are driving in those directions typically. Sasco Hill Road is a 2-lane road, posted speed limit of 25 miles per hour. No sidewalks, pretty much no curbs for most of its section. I had stated in this letter report that the volume was estimated about 300 vehicles in the peak hour AM and PM. And those numbers are based on what we did, the 1 Sasco Hill Road, the commercial development on the corner, I guess be the southeast corner with the bank and the commercial space back in 2012. And we estimated and projected those volumes to 2013. Just for reference, we went out and counted last week the intersection of Post Road and Sasco Hill Road, and the volumes are actually lower than they were in the build traffic volumes for 2013 with that development on the corner. Just for reference, yes?
The volumes were lower than pre-built, or they were
Lower than the volumes we used in the 2012 traffic report for the 1 Sasco Hill Road
Right.
development.
So not necessarily, well, possibly pertinent to this application. The post-build numbers for 1 Sasco, how do they compare to the?
We didn't count those driveways.
You didn't count the
So no, I can't give you an answer, but generally speaking, the volumes on Sasco Hill Road were about 175 versus the 300 I said in the report. In the afternoon, 235 vehicles versus the 300 vehicles in the old report. Post Road, slightly lower than 1,500, slightly lower. So overall, the numbers are about the same on Post Road and lower on Sasco Hill. It's only for comparison purposes,
Yep, no,
and nothing more.
And like I said, that's point of interest.
Yeah, absolutely. I agree. We were a little surprised, actually. Estimation of site traffic for the development itself, the office space, if it was to be reoccupied today, that building, which it wouldn't be, would generate about 3 trips during the peak hours. Again, these are trip generation rates from ITE. You hear that reference often, multiple times in the evening sometimes. The new development, the new office space is about 100 square feet less. It still generates about 3 trips for a peak hour condition. And keep in mind, that's a 1-hour period. There could be another 3 trips in the next hour in the morning. No one really starts at 9 o'clock anymore, and it's more spread out. I think I had mentioned once before, the estimates for site traffic for office buildings is actually going down during peak hours. The one unit upstairs would generate 1 trip during a peak hour. The rate, it really comes out to half a trip, but I just made it a trip. So we have 3 trips today for the old building during peak hour, AM and PM. In the future, with this proposed development, 4 trips. So we're adding essentially 1 additional car or vehicle to Sasko Hill Road and Post Road. Access to the site is essentially the same location for the driveway, about 200 feet south of the site is Post Road itself. Sight lines, we looked at speed. As I mentioned a minute or two ago, is posted for 25 miles per hour, but the speed northbound is 31, and the southbound speed from the Post Road at the intersection is about 18 to 20, 22, and it goes up to, about 25 at the side driveway. Sight lines using the standards we would normally use for, which are from DOT and used by the town. We would need about 350 feet of sight distance, certainly looking to the south. 346 feet. We have about 350 feet, so we meet that standard. To the north, we measure to the intersection. I know we've had discussions about that. That's about 195 feet, and we typically measure to the intersection. If you could see the intersection, you basically meet the standard of seeing as far as you can, in this case, to a T intersection and the traffic signal itself. Yes, sir.
Property to the north, is there a driveway
Yes.
on Sasko or on Post Road?
Sasko.
It is on Sasko.
Actually, I think there are 2 driveways. Yes, so between our site and Post Road, there are 2 driveways for that office building on the corner. Yes.
Thank you.
Yes. So just, it's in essence, traffic generation, 4 trips per peak hour. That's why we don't have a traffic study as far as analyses and so on. Volumes are essentially about the same as a few years ago, maybe a little bit lower. Driveway is essentially in the same location. As we mentioned before, there'll be some landscaping improvements, and I can assure you the trees that Bill's planting and the shrubbery underneath will be designed to maintain and provide sight distance. That, just so you know, you need to see 3.5 feet above grade down the road to a point 3.5 feet. So that would be maintained. Essentially, I won't say this project has no impact. It has a minimal, or really an impact that's not really measurable. I'll just leave it at that. So we don't have any recommendations or need for mitigation off-site from the site itself. And that's a summary of the traffic letter that you may or may not have in your file from the past. Any questions? I'll be more than happy to answer.
Does anyone have any questions for Mr. Klein?
No? Not right now?
Thank you.
Thank you. Appreciate it.
Thank you, Michael. Mr. Chairman, I'd now like to conclude. This application did not require an inland wetland approval from the Conservation Department, in that there are no inland wetlands on site or adjacent to the premises here. You've heard from Bill Kenny relative to the details of the CAM application. You've also heard from Mr. Kenny outlining the tidal wetlands and buffer enhancement work to be performed adjacent to the mill pond, as well as the significant proposed landscaping for the remainder of the site. Drainage report has been made available to the Town Engineering Department. Laura Pulley of that Engineering Department has confirmed in an email to the P&Z staff her agreement with the proposal. There is no Section 24 excavation and fill permit required because the net fill of 138 cubic yards is less than the Section 24 threshold of 250 cubic yards. The relevant zoning regulations are the special permit standards in Section 25. I'd like to briefly review them. Section 25.7.1 is satisfied here since the proposed mixed-use building is a permitted use in the design commercial district. Section 25.7.2 is satisfied here since a detailed site plan has been submitted. The premises, as you heard, will be served by both public water and public sanitary sewer. 25.7.3 is satisfied inasmuch as detailed architectural plans have been submitted. The landscaping plan submitted satisfies the requirements of 25.7.6. The provisions of section 25.7.7 reference the harmony of the design with the neighborhood, protection of values in the neighborhood, and avoiding traffic congestion. The proposed design is certainly in harmony with the neighborhood inasmuch as it's a permitted use in the zone and utilizes, as you heard from Mr. Franzen, an architectural style of New England vernacular, which permits it to harmonize with the adjoining residential property to the south while still being complementary to the commercial property to the north. The building must be elevated to address FEMA standards, and the design includes the elevation necessary to satisfy the applicable FEMA standards. FEMA is mandatory. It is not a design option. The building has essentially 2 floors of usable space, one to be used as an office and one as a 2-bedroom apartment. The 2 stories of usable space are consistent with the commercial building across the street, which has 2 stories, while the directly adjacent commercial building to the north contains 3 stories of usable office use. The elevation of the structures, as required by FEMA, reaches a height just less than that of the building to the north. That is, as you've seen at the beach, a function of the FEMA requirements. To argue that the building should be limited to 1 story because of the fact it's located in the flood zone and is required to comply with FEMA requirements is, I submit, completely arbitrary and unfair. I submit there's no issue with respect to property values when significant resources will be expended to construct an architecturally complementary first-quality building. The Commission will recall that there was a mixed-use building proposed several years ago, the design of which met with virtually a universal disdain. My client engaged Jack Franzen for that very reason, to ensure that a carefully planned design was produced, which recognizes the location of the building between the existing commercial building to the north and the residences to the south. I think that's been accomplished. As such, the building is certainly in harmony with the neighborhood. Lastly, as presented to the Commission, this proposal will not result in undue traffic congestion. The addition of 1 a.m. peak hour trip and 1 p.m. peak hour trip is by definition negligible. As such, this does not result in undue traffic congestion on the streets. This proposal complies with the relevant zoning criteria, including setbacks, the limitation that the residential use not exceed 50% of the floor area is satisfied here, where the residential component is just over 40% of the total floor area. If you need me to run those numbers for you, it's very painful. I will. For the reasons I've outlined, I'd request this application be approved. My client, Mr. Roberts, is in attendance tonight, and he and I, as well as the various experts you have heard from, will be pleased to answer any questions the Commission may have. Thank you for your time and attention.
Thank you very much, Mr. Fitzpatrick. Anyone have any questions?
Thank you.
Very good, thank you. Is there any member of the public that wishes to be heard on this? Anyone?
Good evening. My name is Steve Susik. I own the property adjacent to this property. It's 56 Nasco Hill Road. We share about 140-foot-long border between the 2 properties.
You share the driveway?
That's correct.
Okay.
So a couple of concerns. I know I've been before this board. This is my 3rd time again. I think I'm bringing up the same concerns I had before. The shared driveway, the drawing that I saw here has only access to the 1-car garage. There's a parking space. If I can take a look at this picture. So what the drawing shows is access to this, which is the garage. But you can't see here, they took it out of this particular picture. Just south or west of this tree, there is another parking spot, which is roughly about 30 feet further down the driveway, closer to the proposed building, which is, I believe, pre-existing my ownership. I've seen designs that date back to 1984 that do show that particular spot. The deed,
On your property.
that's correct.
So that you're concerned that for somehow the easement will be constricted such
Yes.
that you will lose a parking space on your property?
Correct, and it's just a one-car parking area here, and I have another spot south of that tree, which has been paved for
Right.
numerous
well,
years.
That's what I want to know.
The deed also does state that I have access to the garage and parking area.
Right here, this way.
So that is in the deed from when they subdivided the two properties.
Where?
Did you hear what he just said?
No.
He said that his deed says that he has access to the parking spot.
It says parking areas. But that's pre-existing, right? I mean, so it's paved, it's there, it's, you know, I purchased the property 6 years ago. That was an additional parking spot.
So this proposed picture doesn't show...
That's correct.
pavement
It's just
there.
south of this tree, or west of this tree, right here where you see the grass. I see the it's paved, a little closer to the tree. And then you have Belgian blocks going further south, which is the border between the two properties.
Mm-hmm.
So this paved, this area here, it's paved, it's not shown here.
I understand that.
That's all on his property
but
right
that's-
now, and that will stay there.
Yeah.
Except it's the access from their side that he's worried.
Yeah, I'm just saying,
Yeah, right.
if the current drawing that they have from the land surveyor doesn't show that second parking spot.
Yeah, they show it on the existing, but not on the proposed, I see what you're saying.
Right.
But the proposed, and I mean, look, normally we don't get into this kind of back and forth, but, you know, but you're in a butter, it's your easement, so it's important that we understand.
I just want the drawing to reflect the current easement.
The current easement across their property is that macaroni-shaped driveway.
That's incorrect.
That's not correct.
That's not correct, because I have another parking spot. Can I show you?
Yes, please. Come on.
Go back to the existing. It's on the
So
existing,
so
right
this is
here.
existing.
So this is all paved.
Hold on, let Mr. Turner.
Yeah.
So this dotted line represents the current paved area.
Right,
of my
that's on
property.
your property.
That's my property. This is the property line right here.
Yep.
Okay, there's a big tree here, and this is another parking spot which we have, which is roughly about 30 feet further west, right? So I would need access, not just as shown here, but I would need access here, and I also need access to back up, because as you know, coming up this grade here,
Well,
you really can't see the Saskatoon Hill Road.
so I understand your point. Thank you. I do. Thank you. You'll have to address that on rebuttal.
And I think in our past commission boards, we did, I think it was part of the notes from the meeting that you guys did note that, perhaps in the second meeting we had before.
Okay?
So that was one of my concerns. The other one is, I also need a turnaround space, right? Because I can't back up into Sasko Hill Road going up that incline. I think that's very dangerous, so I need to be able to do a three-point turn into that driveway, which is my current method of leaving the property.
You back out of your garage.
Back out of the parking spot and the garage
go
to
head
go
out.
forward. And I think, I'm not sure how the configuration is today or proposed, but I believe there are no parking areas that would prevent me from doing that, but I would like to have that shown on their design. The other concern I have, currently there's a number of trees planted right along this edge, which they're going to turn into a parking area. There's roughly about 10 trees currently that are, they're mature trees, various types. There's roughly 10 feet. It's not paved off this current retaining wall from the commercial property off the post road. So there's about 10 trees here that are going to, according to this view, they're going to take down. I didn't see that they were going to plant another 10 trees or what's existing there. I think they had a couple trees. I think they were using some of the trees that are currently on my property as part of theirs. So just I don't know what the correct amount of trees is for a commercial.
Well,
property is, but
I think, so your concern is that those trees are a buffer between
Correct.
your view,
and the post road and the
big
commercial property. I mean,
commercial property.
this is somewhat of the view, but these trees are all on 54 Sasko
Right.
Hill Road, and they're all kind of from this point towards Sasko Hill Road.
Right, I understand.
There's a
And-
variety of them. So if we could do something about that, that would be preferred. The other thing that happens right now, which I think they can, the design, the engineering design, we get a lot of water coming down the driveway from Sasko Hill Road. I think, if they raise the driveway a couple inches, we can prevent that and it could go down to the storm drain. I think that's closer to the post road. But right now, when there's heavy rain, this whole area becomes, coming down pretty hard. And it makes its way from their property onto my property and then into the Mill River. Okay.
You do understand that the plan that they propose completely sort of, I don't want to say regrades, but does install at various grades, complete infiltration system, 5 stages. I mean, you heard all that, right?
But I think what their calculation is related to is their property, not any runoff that's coming down Sasko Hill Road itself. Because Sasko Hill Road's pitching down towards the common driveway. And right now, the driveway, over the years, is lower than the road. So that rainwater comes down basically this driveway and goes down into the Mill River. I would just say I think that's a simple design solution there, just that they need to elevate it, make sure that's normal, but just something to consider.
Do you have dialogue with the owner and the applicant here?
No, no, I have not.
Have you folks tried to communicate?
I haven't. I've talked to the architect maybe last October, I think it was, about 9 months ago. Saw the previous design, raised some of my concerns. At that point in time, the height of the building is going to be significantly different,
Mhm.
I mean,
I was just curious if there was any issues there, or if you tried that first. Okay.
And then I think the last thing I have, the location of the garbage dumpster. Right now, it's proposed to be on the residential side. If we can put that in the garage area or on the commercial side, that would be preferred. But right now, with the current residential properties, we kind of look down on this property, and, even if they put a 6-foot fence around it, we'll be able to see right down on the dumpster. Another concern is, I think, the garbage truck, depending on how big they are, or commercial vehicles, will also have to, do a 3-point turn in this area in order to, access Sasko Hill Road.
I don't understand the last concern about the 3-point turn.
Well, for a large vehicle, like a dumpster, a garbage truck, he's not going to be able to back up. It'll be difficult to back up the driveway because, again, it goes from roughly a 10-foot elevation to 13 feet.
Right.
And so when you're coming up, if you're not going forward, it's hard to see oncoming traffic, especially coming off the post road, because typically...
Yeah, that's if he doesn't back in.
True. I'm just saying, I'm not...
My guy backs up my driveway.
Okay.
I think they'll probably be able to figure that one
That's
out.
fine.
Okay.
Those are the concerns I have.
Very good. Thank you very much. Any other members of the public wish to be heard on this item?
Good evening, Mr. Chairman, members of the commission, staff. My name is Joel Green. I practice law in Bridgeport with the law offices of Green and Gross, and I appear before you this evening on behalf of Sasko Associates, the owner of the property at 10 Sasko Hill Road, which is the office building which is shown here. I have some significant concerns regarding the conformity of this plan with the zoning regulations, but I just have a few questions, and I don't know whether the I'll just offer them to the commission, and you may ask the consultants for the applicant or not, but based on,
So hopefully they're taking notes.
I hope so, but based on the comments by Mr. Susick, and I spoke to him briefly, and I've spoken to him in the past, I just want to be clear, the engineer had a site plan of the, I can refer to the board of the proposed, yeah. So just to piggyback off the comments by Mr. Susick, it's not clear
Mr.
to me,
Green?
there's a legend on the plan.
Mr. Green, Mr. Green, just hold on 1 second. Are you asking me if you can leave?
No, I don't, not at all. I'd love to get it heard tonight, but I just want to, I know people are here on.
On that application, on those applications on 1073?
Yeah, I'm
Okay,
happy to stay, but.
all right.
I'm going to
No.
be 5 minutes,
Yeah. All right.
I promise.
Yeah,
The
I
question-
think others are laughing for a different reason.
Yeah, I'm sure of it. I'm sure
But
of
please
it.
continue.
Yeah, quickly, just quickly. I didn't, there's a legend on this plan that says limit of pavement at property line, and shows a legend here. I'm unclear as to what the applicant's proposal is for paving here. I note that Mr. Susick has raised an issue, and as you could see from the existing plan, and based on my conversations with Mr. Susick for over 30 years, this driveway, not in addition to this, once again, elbow macaroni-shaped access, apparently a larger portion of this property has been used for access to 56 Sasko Hill Road, Mr. Susick's property. So I just urge the commission to maybe ask the applicant what the intention is. Is this going to be paved to this area? And as a follow-up to that comment, I note that there's only 45 cubic yards of fill permitted, proposed for the driveway based on the calculations. I note that there appears to be, the whole site seems to slope to the
Down.
south,
Mhm.
and I didn't note any sort of facilities engineering to catch stormwater in that area, and based on the spot elevations that were shown, there does seem to be a significant slope going this way towards Mr. Susick's property. I wasn't sure, I'm not sure, based on the plan that's proposed, what the true extent of the paving is, because the only real representation are some curves here. I don't know whether the paving actually ends here. I presume it does. But the commission might want to ask that question. The commission might want to ask whether this was apparently a revised plan, and I question whether the revised plan was shared with the DEP with respect to the CAM application, or was the CAM application strictly based on the original application. And once again, my client has significant concerns as to the conformity of this with the regulations, but I have nothing further to offer the commission at this time.
Okay, very
Thank
good.
you.
Thank you very much. Any other member of the public wish to be heard? Okay, Mr. Fitzpatrick.
Mr. Chairman, members of the commission, first of all, without conceding the legal right to the access of that other space on Mr. Susick's property, we see no difficulty in crossing over our lot to access that space as long as the parking is on his property and not ours.
I think that's clear. The space is on his property, but his contention is that for years he has been traversing other parts of your driveway other than that macaroni-shaped elbow in order to do so, and he's been also using other portions of the driveway to make three-point turns and the like for ingress and egress, etc. So are you committing for the record that activity is permitted to continue?
We will permit that activity to continue.
Okay? So we can make that as a condition of approval then.
You can.
Okay, thank you.
Secondly, Mr. Kenny, would you like to very quickly address those trees along the, confirm what's going to happen to those pines? Did Mr. Susick express a concern about? They're going, right?
On the property line of 10 Sasko.
I'll address them. They're coming out. We need that for the parking. They're unattractive. We have a detailed, comprehensive landscaping plan. We are improving the property from a landscaping value significantly. Jimmy, can we confirm that any drainage from Sasko Hill Road, that is being picked up? Up here to the mic, please.
Again, James Zumo, Land Surveying Services. Our regulations state we have to mitigate the drainage on our site. I can consult the engineer and ask him if he took into account that, but regulations state we have to control any runoff that we are creating with new or proposed improvements on our site. What
Correct.
comes off of Sasko Hill comes off of Sasko Hill. There's,
I think that the point is, and, you know, likely well taken, is that that might be the letter of the regulation, but as a practical matter, there is water flowing from Sasko Hill in those same storms that's coming onto your property and through to the other property, flooding, going to the mill pond. And whether that was taken into account in your calculations as to the water on your site being mitigated.
If I can, just, Mr. Chairman, if I can speak to confirming with Mr. Wendt, the town will require, in essence, a hump between the gutter and the property. And please keep in mind that Laura Pulley of the engineering department has already signed off on the entirety of this drainage analysis.
So the answer is that you did take it into account because in construction there will be a hump and there won't be any water running down Sasko onto the property in the future.
Correct.
Thank you.
I would note, Mr. Franzen did meet with Mr. Susick. The location of the dumpster, we simply can't, we don't have room to change it. It's here, it's in an enclosure.
Yeah.
The other side has the handicapped ramp. There is just no room. And I think that,
How about a cover? His concern is that in his residence on the second story, he's looking out, down, past the 6-foot fence, down into an open dumpster.
peaked roof, couple of eaves, little dormer.
Something like that.
We'll see what we can do.
Some evergreens perhaps around it?
Addressing Mr. Green's points, we will make the pavement if it doesn't reach Mr. Susick's parking space. Stormwater issues have been addressed again by Laura Pulley. The revised plan was not shared with DEEP. The revised plan has nothing to do with DEEP because the storm drainage is one and the same. We moved the building 3.5 feet. Mr. Green's significant concerns with other nonconformities were not expressed, so it's very difficult for me to address them. In our opinion, we fully comply with the zoning regulations. We have nothing else for you unless you have questions for us.
Very good. Mr. Francis?
Mr. Susick's view of the parking lot on the post road, is that going to be anywhere near as shaded as it is now?
As
As it is now?
I don't think there will be
Shaded,
significant...
I don't mean sunshade, I mean protected, screened as it is now. Once you take down all those deficient trees.
The deficient
bushes.
trees are on the other side of the property. They don't affect his view of the property at all. They're here. They're on the northerly
I thought he said
side.
he was concerned that he didn't want to look at that building and parking lot particularly.
the building over here.
Can we see the picture instead of that, for what we're talking about, the site conditions?
So those pine trees are coming down,
These, yes.
and what's replacing them?
Mr. Kenny's landscaping plan shows
Nothing.
Nothing, retaining wall,
there's a
parking.
lot more than nothing.
It's
On
just
that side,
nothing there.
Nothing right there.
No, nothing along that side. We need to park right up to that property line.
That's not the landscaping plan.
That shows the planting
Those,
on the south.
well, those two are existing trees on the left.
Are any of the plantings along the southern edge going to be of significant height, even along the property line to Mr. Suzak's property? Or are they low shrubs? Are they of a height that might help screen this property at some point?
Could you repeat that? I missed the
Like the
first
stuff
part.
along the southern edge, I think, yeah, the southern edge.
So this is an existing mature
But the
tree.
lower ones that you're putting in underneath, what kind of height is on those?
On these shrubs?
Is that, those are all shrubs, so they're all like 4 feet, 5
Yeah,
feet?
these are shade trees here proposed. A shade tree here proposed, so that'll be a large tree, an existing large shade tree right here.
All right. So
I think the answer is that there are no trees that are going on that northern border at 10 Sasco. It's private property, and that's not part of the plan.
But there are some things on the southern that might be
Yeah.
helpful.
Right, but Mr. Gallianti said that they had to be low enough to not interfere with sightlines.
Out of the street, but the stuff further west toward the building that might shade the building a little bit, or soften the base of the building.
Okay, we can discuss this in executive session.
Yeah.
I think we have the answer.
Thank you very much.
Thank you. And with that, I'll close the public hearing on this item.
So this is,
We'll see.
Matt?
We're leaving in 15 minutes. You got me.
Past my bedtime.
Let's see what you can do in 15
I can do it? If you give me a...
So, I'm gonna call, you gonna treat these in seriatim, or?
Yeah, I mean, I think I should treat them as individual applications because they're different, but I can get through all of them, I think, without being presumptuous, depending on questions you might have. I would hope within 20 minutes, 25 minutes.
No. Yeah, it doesn't, I'm sorry, because and it's really, it's not, not practical either, because if you're gonna treat each one of them individually, I'm gonna go to the members of the public, we're gonna go back and forth.
Well, I can do it as one. I mean, it's up to you. I mean, we can do a combined hearing on all
And I
three.
also- yeah, so,
We'd love to get the townhouse one in particular heard tonight for...
all right, let's do them individually. That way, if we can get one in
Right.
tonight, we'll get one in tonight, and we'll...
The
okay,
townhouse
so-
would be helpful particularly because, you know, we'd like to...
And that's the first one up, so I
Okay.
take it in order. Next item is 1073 North Benson Road, special exception application of Fairfield University pertaining to proposed student townhouses in the AA zone.
Thank you, Mr. Chairman. For the record, my name is John Fallon. I'm here tonight on behalf of Fairfield University. As you say, we make this application for approval to construct a new dormitory in the southwest corner of our campus, as shown on the plans that were submitted. I would point out that due to the topography, generally, this building will not be visible to any off-site properties, with the possible exception of our president's house on Round Hill Road. And he has no objection to the application, as I understand it. This new dormitory will be constructed in an area that served as the location of structures utilized by the university's facilities department for trade workers, break rooms, storage. If you've been in there, we have mafia blocks stored there, construction materials, gas tanks, things of that nature. As part of this building program, as you can see, The university will construct a new, smaller maintenance facility west of the current structure. That new building at 7,500 square feet will be substantially smaller than the current structure, and some departments utilizing the current facilities will be located elsewhere on the campus. As an undergraduate student residential experience, that is probably one of the most critical components of the value of a Fairfield University education. The university is committed, as it has been with your help over the last few years, to improving both the quality and quantity of our on-campus housing stock. Recent investments in that regard have included a new 200-bed sophomore dorm, which opened just a few weeks ago and is now occupied, renovations to the existing quad dormitories, and a multi-year renovation program for the townhouses at the northeast corner of the campus. Quality and available on-campus housing is critical for the university as it remains competitive with its peer institutions. The specific proposal that's detailed in the plans we've submitted is for a 200-bed development designed to provide quality living space for university's junior and senior students. It'll provide a better distribution of housing to all four corners of our 210-acre campus, and that's particularly important due to the location of the new Dolan School of Business, which is, as you know, under construction. The townhouse units with their own separate entries will also represent a movement towards independent living, preparing the students for the experience they will encounter after they graduate from the university. The proposed new dormitory will provide a high-quality alternative to off-campus housing for those students who would prefer to remain on campus. Also, as we have found, and you have found, with regard to prior applications, keeping these students on campus, providing additional on-campus housing, as opposed to have them traveling multiple times a day to and from campus, from off-campus housings, has a very positive impact on local traffic. We've reached out and talked to our Winton Park neighbors, and our drainage plan is prepared by the Huntington Company, has incorporated certain aspects of protection that they are very pleased with. Walter Jobst from the Huntington Company is here tonight. Should you have any questions with regard to the drainage plan, you've also received a review with regard to this proposal from your town engineering department, which has approved it. The property is located in the Residence AA zone. The use that we propose for these dormitories is permitted pursuant to Section 5.1.4D. We held a code enforcement meeting on July 17th, 2018. All aspects of the code-related plans, the code comments have been complied with regard to the plans that have been submitted to you. We did receive a certificate of wetlands conformance, number 2017-18-131, from the Conservation Department. You have a set of detailed architectural plans that have been presented to you. Our architect, David Clemenzi, who is a principal of EPY Architects, is here tonight from Albany, New York. If you have any questions with regard to the architectural plans. But in summary, what this simply is an application that will benefit not only the needs that we have in terms of providing quality on-campus housing to our students. It will reduce off-campus traffic with regard to multiple trips to and from campus by our students. The new townhouses, we think, have been very sensitively and architecturally designed to ensure that they'll have an attractive appearance, harmonize with the character and ambiance of the campus. And as I said at the beginning, they're located in a location of our campus where they're not going to have any off-site impact or very, very limited off-site impact in any event. This is an important component of our continuing commitment to providing the finest facilities overall for the quality of student life on campus. And of course, that quality of student life is often measured, importantly among other things, with quality on-campus housing. So we'd be pleased to answer any questions you or the members of the public might have with regard to this specific application before I address the other two that are pending on your docket tonight.
On the site
Yes,
plan,
Commissioner. Yes.
What am I looking at? Round Hill Road.
Mhm.
Is there a gate there? I don't remember. Is there an entry? I know
There is.
Do students have access in and out of that?
There is. Yes.
There might be additional traffic coming in and out of that?
There is a gate there now. It's been there for many years. You know, we have our student, the Early Learning Center there, and so it's there, and, you know, we plan to maintain it. It will help actually disperse traffic, I think, from, you know, when these new dorms are built too, from Barlow, North Benson. It'll be a more direct entrance to these townhouses.
Where's the cross-section of the attic?
Mr. Clemenzi, could you come forward? I'd introduce David Clemenzi, who's our architect, and he can direct any questions you might have with regard to the architectural plan.
Thanks, hi. So one of the TPZ comments from the code was to show a cross-section of the attic.
These are the plans you already have, I believe. Correct, Mr. Bishop, use copies
Yep.
of what's already submitted?
Give me a second, I'll just find it. I'm sorry, the building section doesn't appear to be in this set. It was in the packet that was provided in the submission.
Can you look at that, the submission package, Mr. Clemenzi, that Mr. Wentz has, point them out to everybody?
What I can do, Commissioner, is actually show you the exterior elevation, which does call out the elevations that I think you're interested in, which is the overall clear height. So I'm looking at the overall front elevation, which is A201. So A201 illustrates in the top right the attic section. Right. So one of the requirements from the code enforcement meeting was to show a cross-section of the attic so that we have less than 7 feet to the underside of the ridge. Right, and the elevation that's indicated here is the 6'10.5", which is that roof section to the bottom of the ridge beam. See that? These elevations are not in our large plans, are they? Yeah, I can't read that. These glasses aren't strong enough.
They're in the large plan.
They are?
It's in the large plan, but not the reduced.
What sheet is that, Jim?
So it is in the reduced. Right here.
A201.
Thank you.
On the base side.
Thank you. You'll notice we've got top of truss rim, or bottom of cord to the bottom of the ridge beam is 6'10.5". I just, we're trying to be efficient here. Yep. For fire, 3-point turnaround radius on the
Yes.
northern driveway.
You have an email yesterday from Deputy Chief Edmonton confirming that that he is satisfied that it's been provided.
I had an email? Do I have that email, Mr. Wayne? No. I didn't see that email.
Can I ask a quick question?
Commissioner Francis?
Do the windows open?
Yes. Yes, all the windows open.
Have the Winton Park Association residents been notified?
I'm sorry, could you repeat that question?
I'm sorry?
Have the Winton Park Association residents been notified and worked with?
Well, everybody was notified in accordance with your requirements, but there were specific conversations, I'm told, with some people in Winton Park, specifically about the drainage. But yes.
I would think they'd be more concerned about the noise.
We've met with them. They were all
Playing
given
music
notice.
from 10 PM to 2 AM?
All these units are air conditioned, they don't have balconies. To answer your question directly, yes. All the owners of Winter Park have been notified, and we have had conversations with them. And I don't know if any of them are here tonight, but they're aware of that.
I'd be on my mind if
Also, the buildings, Mr. Points out, were oriented so they would not have any direct impact on Winter Park, plus their air conditioned, as I said. Mr. Wood, do you have Mr. Edmonds' email?
I have it, whether it's in this file or not is what that.
I have it as well. But I can represent to you, Mr. Chairman, that there is a letter from the Deputy Fire Chief, an email from the Deputy Fire Chief, as of yesterday afternoon. The Fire Department was very busy.
They were very busy with you?
Station Street on Red Hill Road.
And it does confirm that we did supply that turning radius and they're satisfied. We'll get you a copy of that.
Yes, please. Is there a, just point me to the sheet on which that turnaround appears so that I can see it.
I mean, where they're talking about.
Yeah.
They're asking for it up here, C5. That's what they're asking for. They don't show it there, but that's what they want to see.
There it is.
Right at the top of C5?
You got it.
There's an email which I will give to the chair, Mr. Wentz, too. It's from Lieutenant Jeffrey Edmondson, and it goes to Mr. Wentz. It came yesterday at 1:41. Jim, Walt Stapleton dropped off plans regarding the fire apparatus turnaround for the proposed maintenance shed on the lower Fairfield University campus. The turnaround on the plan is sufficient for our apparatus as shown and as discussed at the code review meeting. We will do a practical test prior to the certificate of occupancy when the site allows. Thanks, Jeff Evans.
Great.
Is that to the townhouses or the mechanical shed?
Right in front of the mechanical.
These are the townhouses.
Or is it both, I guess?
Yes.
It's okay for the maintenance building.
So,
It's on sheet C5.
C5,
Yeah, it's right,
proposed maintenance shed.
Show us where it is.
Okay.
Chairman Wagner.
So, yeah, thank you, go ahead.
Right.
It's right there.
Asphalt pavement. That's, how does that work? I'm not challenging that the fire department reviewed it and that they say it's acceptable, and I just want to understand where on the plan that appears and how that works.
Okay. All the jokes.
Thank you.
For the record, Walt Jobst, professional engineer, land surveyor with the Huntington Company. I'll have to sketch this for you, but basically, fire truck would come up this road.
Yep.
It would turn in here. And this gray area, again, is all asphalt pavement. It will turn in here, it will back up here,
And then
and
turn
exit
around.
out that way.
Got it.
So we did a study on that. That was presented to the fire department and was approved.
And that's behind the proposed maintenance shed.
Yes.
Correct.
Very good. Thank you very much. Do you want to hand?
keep that for the record? I can get another.
Well, hand it to Lois. Thanks. All right. Okay. Does anyone else have any other questions for Mr. Fallon? Okay, thank you. Does any member of the public wish to be heard on this item?
My name is Charles Rudy. I live at 140 College Park Drive in Fairfield. Just a couple of points of clarification, if I may. Mr. Fallon, did you say this is a junior townhouse complex.
So you should just direct your remarks to us
Fine.
and ask your questions, and if I know Mr. Fallon, he'll take close notes and he'll answer on rebuttal.
Thank you, sir, thank you. I'd like to know, I think this is for juniors, if I understood correctly, third-year students, exclusively for them. 200 beds, and again, a point of clarification, I think that's what I heard. And I would like to know how many parking spaces are allotted for those 200 beds.
Okay.
I do know, I believe juniors and seniors are permitted to have cars on campus, so it's highly relevant to this particular complex.
Yep, and they do propose parking, so we'll get those details for the record.
Thank you, sir.
Thank you. Anyone else?
Good evening. My name is Gene McLaughlin. I live at 11 Deer Run, which is at the northern end of the campus. I found out about this late last week or this weekend. I went to the Planning and Zoning Office Monday, met with, caught Mr. Wendt and Mr. Fallon. They were very helpful in explaining the thing. But thinking it over, I think there are some issues here. I think Mr. Rudy touched on one of them about the parking. In the past, we've had problems with the overflow of students who don't get parking spaces on campus going to the side streets. So I think that's a major issue. The other issue I have is that this is a lot of density of individuals and housing. And it's been kind of drawn, my attention has been drawn to it as I've been sitting through these hearings, that parking, in addition to parking, there's a traffic issue that is usually presented before your commission of what the impact of traffic will be. So this is going to be, if it's 200 beds, and I don't know how you figure your ratios, but if a subdivision, for example, is figured to be 4 or 5 people per house, this would be like a 40-lot subdivision of people coming in and out. So I think there's going to be a major impact on traffic coming on Round Hill Road, which is a somewhat heavily traveled now. I'm concerned it's going to be even more impacted. And I don't think it's really designed to take, heavy traffic of this type. I think what I heard Mr. Fallon say was that this will alleviate traffic because the students will be on campus and therefore won't be commuting from the beach or whatever. But when you think about it, this is going to be a residence area with upperclassmen who have access to cars or can have cars on campus. And there's going to be and they're going to come out on the gate that's on Round Hill Road. So I think this should be, like your other applications, I think there really should be a traffic analysis done to see what the impact is. It didn't immediately hit me, but now that I hear the numbers and have seen what careful consideration, even a minor, what I consider to be minor development in your other applications is, for something of this scope, I think that traffic should be addressed. I think there should be some statistics on it, and if it is within what you normally consider to be should be addressed, then that should be also part of this application. So I think that's an important point. I don't think, I don't want to wake up and find out that suddenly there's a lot of traffic queuing up as I try to get to work or whatever. I think there's going to be a significant increase when you think about what any individual does when they're out of residence. They're in and out every day, several times a day, run errands, go shopping, go out to eat. They may have certain times when they want to hit this area, and just the scope of this is really much more major than some of the other things you've had, and whether you've had some really detailed traffic studies. So I think that's something that should be addressed. It may be that it's not. but I can't help but feel that it is going to have some impact. Now, how could this be addressed? I don't know. I'm willing to discuss it with the university. There's a state highway on the other side of the campus that has a traffic light. You know, these are things that we could probably discuss. We did not have an opportunity to discuss this with the university. The other thing that...
Did you not receive notice of this through the mail?
I did.
You did, okay.
Yes, and it was, I think, late last week. I was away over the weekend. And normally, we've had some public relations meetings with the university, but this one did not have that for some reason. The other thing is that some of your other applications have gone into the ratio between the floor area and the site. I don't know exactly how the university is supposed to comply with that. I remember in some other applications that have been presented, this has been touched upon that there is some kind of ratio. Whether they're getting close to it or not, I'm not sure. But I think that should be reviewed as to whether they are nearing the peak of this or not. But those would be the major issues. So I think when you think of the density that's really here of 200, and it's not just maybe 1 or 2 cars per house in a subdivision, but all these 200 people will potentially have cars. So I think that should be addressed. So thank you very much.
Okay, very good. Thank you very much for your comments. Does anyone else wish to be heard on this? No?
5 minutes.
Yeah. Yeah.
As long as the comments are fresh in your mind.
Give me a moment. Give me a moment. Yeah. Yeah. Yeah, so in light of the lateness of the hour, I'm going to continue the hearing, and perhaps in that time we can focus some of the responses on some of these issues.
Well, can I just ask a question as we're doing that? And I'm not trying to, I'll beg off. We have a complete parking analysis. I won't bother you with that tonight. Very quickly, the zoning data chart lays out the coverage
No,
and
I
FAR.
understand.
But here's my question. I really question the premise of Mr. McLaughlin's statement. These are students who are here now. There is no increase in enrollment associated with this.
Mr. Fallon.
Do you want a traffic analysis? I think you haven't taken them in the past.
No.
With regard to dormitories, on the basis that you understand that what we're doing is reducing. So I don't think Mr. McLaughlin should come in here on his premise, which is faulty, and have you change your policy.
You shouldn't read into my desire to go home
I understand.
at 10 after
Your
11.
volunteer service is appreciated.
After hearing everything that we've done tonight
I appreciate it.
on a project of this scope, you wanted to do all 3 in 15 minutes.
Well, I didn't
Talked you
suggest-
down off the ledge, okay?
I suggested we could try.
All right, so I think that it is entirely reasonable that we adjourn and hold this hearing open until our next meeting. And if there are things that need to be done in the interim, so be it. But,
Chairman, you're always reasonable.
okay?
Amen, amen.
I will continue the public hearing and I'll adjourn the meeting. Thank you.